Well, hello everyone, and welcome back to Uncivil Law, where we learn through the misfortunes of others. As always, I'm your host, Uncivil Law, a licensed attorney in Texas, Virginia, and before the United States Supreme Court, and I hope you're just having the most fantastic and wonderful of days. For today's story, we've got a particularly interesting opinion from a federal court, which will almost certainly get me demonetized immediately. This is not for the monetization, this is for how blue do you like it? Do you like your evenings blue? I hope you do, because this one's pretty blue. This is the case of Denise Jones versus Atlantic Records. Denise Jones is suing Atlantic Records for copyright infringement. She says that the song Wet Ass Pussy was a copyright infringement of her song Grab 'Em by the Pussy. And she has a prior claim to this pussy-related language. So she is suing for the copyright infringement, and the federal court actually has to deal with this with a lyrical analysis of the twin songs. So we're going to read some lyrics. How exciting. Let's learn a little bit more about this. All right, we're in the United States District Court, Southern District of New York. Denise Jones versus Atlantic Records, Warner Music Group, 1501 Certified Entertainment, 300 Entertainment, Megan J. Pete, Jordan Thorpe, Berklis Marlins, Almazar, Craig Kalmazan, Stephen Cooper, Carl Crawford, and Kevin Lyles, in an opinion and order from the judge Andrew Carter. Plaintiff Denise Jones, who proceeds pro se, which is always a great place to start, proceeds this action against the defendants, who we just mentioned, for copyright infringement of her song, Grab 'Em by the Pussy, by the defendant's song, Wet Ass Pussy and Thought Shit. She thinks that Wet Ass Pussy and Thought Shit infringe her intellectual property in the song Grab 'Em by the Pussy. Defendants move to dismiss the complaint pursuant to Rule 8, 12, and 12 of the Federal Rules of Civil Procedure. For rules set forth below, the court finds the complaint fails to state a claim of copyright infringement as a matter of law, and the motion to dismiss is granted. So, not so much for our would-be friend wanting to sue Megan Thee Stallion and everyone else for the copyright infringement. It isn't seem to be happening. Why isn't it happening? Let's learn more. When determining whether to dismiss a case, the court accepts as true all well-pled factual allegations in the complaint and draws all reasonable inferences that therefrom. You guys know this, right? The person's complaint is going to be basically accepted as true, because even if true, can they win? If the answer is no, then we're done. So we'll assume that everything they say is true, because if they're right, then and they can't win, then what's the point of going forward? The following facts alleged are thus assumed to be true for the purposes of the motion, because how that works. The plaintiff is an independent artist performing under the name of Nessie X. So if you're interested in the works of Grab 'Em by the Pussy and other works, they apparently work under the stage name of Nessie X. Plaintiff alleges at one time that she partnered with Matthew Thorpe, a non-party, on an independent living company that provides housing and wraparound service to adults. Matthew Thorpe is allegedly defendant Thorpe's father. This partnership dissolved because Thorpe couldn't hold up his end of the contract, and the dispute was eventually resolved in plaintiff's favor in court. So plaintiff apparently at some point had a business relationship with the father of one of these people, which apparently ended in her favor. So I guess she thinks that, she's still entitled to some things. Plaintiff alleges the dispute served as a motion's defendant to retaliate against her by the infringing works. On December the 8th of 2019, plaintiff created her song, Grab 'Em by the Pussy, which she describes as follows. It was created in a mildly provocative manner to grasp the attention of the fans, but the music we had a message to women in the world. Grab 'Em by the Pussy was to encourage women to get inside the system and make a change. It's art, so it was created in a way to appeal to everyone. The persona of the art is wild, sexual, rebellious, and political. The song was inspired by Trump saying, so the song was designed to talk about the wild side of politics. The creative work shines work to women like Monica Lewinsky, Marilyn Monroe, and Kim Kardashian. Women who are in politics and sexualized, but plays a major role in their changes for either good or bad. So I guess she's been inspired by the works of these brave heroines and also Donald Trump to create a song entitled Grab 'Em by the Pussy. So that is what's going on apparently. Defendant Peep, for his part, is a rapper who performs as Megan Thee Stallion. Defendant Almazar is also a rap artist who performs as Cardi B. Defendant Thorpe is a rapper and songwriter who goes by Partisan Fontaine. Together, on August the 25th of 2020, Pete, Almazar, and Thorpe collaborated on the hit song Wet Ass Pussy. Thorpe and Pete also collaborated on the song Thought Shit. Plaintiff does not allege that Wet Ass Pussy and Thought Shit sound like Grab 'em by the Pussy. Rather, she alleges that in creating the lyrics for Wet Ass Pussy, they copied and pasted her lyrics, though she admits that sometimes they use different slang terms only the community culture could interpret that mean the same thing. So they're like, they copied my words, but maybe with some mild substitutions, which, fair enough. If they copy your lyrics, but they replace some words, maybe it's still a copy. So, okay, fine. Plaintiff alleges that she knew that she had published the work on BMI and ASCAP, so they took the parts they really like and displayed it on a larger scale due to financial advantages. Specifically, plaintiff alleges defendants took the lyrics, pussy so wet that I got the N-word wildin', pussy so wet that we got the N-word wildin', from Grab 'em by the Pussy to create, it's that WAP, it's some wet ass pussy. So apparently that was the inspiration for the Wet Ass Pussy lyrics, I guess. Plaintiff also alleges that the second portion of the lyric, I got the N-word wildin', was copied to create Why You in the Club with N-word wildin' in Thought Shit. Plaintiff alleges that at least 14 other lines were directly copied from 3 of her songs and used in Thought Shit, although she does not specifically name the songs or specific lyrics in the complaint, which is always a really good place to start, right? I allege that you stole my work, but I'm not going to tell you what work or what lyrics. So, okay, fine. Plaintiff also alleges the defendant mocked, stalked, and harassed her in various ways. For instance, plaintiff alleges that she derived her nickname, Nessie X, from the character Niecy, played by Halle Berry in the film Baps. WAP was inspired by Baps, which plaintiff believes was done on purpose by the record label and their employees to wordplay on Nessie X to let the plaintiff know they are bullying her and taking her style. Okay, so, all right, so this is like 6 degrees of Kevin Bacon over here, so, pay attention. The plaintiff, who goes by the stage name Nessie X, says that she got her name from the character Nissy, which was played in a film by Halle Berry in a film called Baps. Okay? So she got her stage name, Nessie X, from Nissy, from a film called Baps. So she says that Megan Thee Stallion called her song WAP in order to be a sign to her that they were copying Baps. All right? The reason they called it WAP was because it sounds like Baps, and this was a subtle cue from Megan Thee Stallion et al. That they were doing this on purpose to poke at her. The reason it's called WAP is because it's based on her character from a movie called Baps. I know I just explained it like 5 times, but I felt like I had to because it doesn't make any sense. So, okay. So she thinks this was done as part of a deliberate conspiracy to bite her shit, as they say. She explains that the music video for WAP, defendants used her trademark hairstyle and expression to copy, annoy, and mock her. So the reason that the people in the music video look the way they do is because that's her style, and they're copying her to, like, invoke her style or something. Okay, fine. Additionally, plaintiff maintains that she was stalked via her social media, which defendants used to further mine her content for works. So apparently Cardi B and Megan Thee Stallion are spending their free time scrolling social media, particularly hers, for inspiration for their lyrics. Okay. She also makes allegations about other individuals' conduct toward her who are not named, such as Crystal Woodford, her former stylist who posed as her best friend and scammed her, and Digital X Records, who allegedly posted a video detailing how plaintiff and other artists have been sacrificed so they can steal content. Well, she certainly has a WAP-sized ego, I guess. Plaintiff initiated this action February the 2nd of 2022. The summonses were served on all the people that we mentioned before. On February 22nd, plaintiff filed a motion asking this court to issue a subpoena to all defendants to authorize and order the service providers to expeditiously disclose to the copyright owner or court's information sufficient to identify infringers to the extent the information is available. The identity of Megan J. Pete, Partisan Fontaine, and Balcazaz Malnaz Almazar. The court denied this motion without prejudice. Defendants Pete, Thort, and Almazar have not yet been served with the summons and complaint because plaintiff didn't provide an address for service. So, we're getting an order on a motion to dismiss even though the defendants haven't been served yet, which gives you an indication of just how pissed the court is, right? The courts can just dismiss stuff sua sponte, and basically that's where we are, right? The court is going to dismiss this out of hand before the defendants even are served because of how bullshit this lawsuit is. Fantastic. Defendants Atlantic, Warner Music, and everyone else filed a motion to dismiss, arguing that the claim fails to state a claim for copyright infringement and that Lyles, Cowman, Cooper, and 300 Entertainment were not served. And then there was also a motion to dismiss by some other people. All right, so we have to decide whether or not to dismiss this thing or not. So let's go ahead and do that. On a Rule 12b6 motion, a court must assume all well-pled factual allegations to be true and determine whether they plausibly give entitlement to relief. As stated before, we're going to assume everything you say is true unless it's just patently absurd. So if it has even a veneer of reality to it, then we'll assume it's true and we'll give you every benefit of the doubt to figure out whether or not this thing should go forward. Allegations that are no more than conclusions are not entitled to assumptions because you're not entitled to your own conclusions. You are entitled to your own facts for the purposes of this motion. So you can tell us what the facts are. The court will draw the conclusions. Thank you very much. We also do not look at naked assertions devoid of further facts or defendant unlawfully harmed me accusations that are not sufficient to show. So you can't just say defendant did it bad. You have to be a little bit more specific than that. Like, what bad? What did they do? So just saying defendant hurt me, I'm going to need more than that. Additionally, a document filed pro se is to be liberally construed, and a pro se complaint, however inartfully pled, must be held to a less stringent standard than formal pleading drafted by lawyers. In particular, the proceedings of a pro se plaintiff must be read liberally and should be interpreted to raise the strongest arguments. So the court will help you along the way because you're representing yourself and try to give you a little extra benefit. All right, so let's now discuss the law as it relates to all this. Defendants argue plaintiff had not adequately alleged a claim of copyright infringement because she does not allege defendant had access to grab him by the pussy, which is kind of important for copyright infringement. If they don't have access to the work, then they can't infringe the work. As long as we're trying to do something like legally and get something legally avowed out of this, it is completely possible, as far as the law is concerned, for two artists to independently create the same or substantially the same work. And it actually happens more than you might actually expect on first blush. And it seems to happen in like close pairings. And there's examples in like Hollywood and music and other arts. It also happens in patent law more than you might expect, where multiple different people are coming up with essentially the same thing at essentially the same time. Something about it being the zeitgeist of the moment, maybe, and whatever it is. So actually that happens more than you might expect. So if two people independently create the exact same work, they both have copyright in it because they didn't copy from each other, right? You only have a right to prevent people from making copies. If another artist, completely independent of you, just happens to create the same work, which again, does happen, then there's no copyright infringement. You have a copyright in yours, they have a copyright in theirs, even though they're kind of the same. This would happen a little bit more often would for example, with just people taking photos, like on their cameras or their smartphone devices, as people are like touring famous sites or something, right? People are going around snapping photos all over the time. Every single one of those photos is subject to copyright, but the tourists are going to look at the exact same thing, right? So it is undeniably true that multiple tourists are taking essentially the same photograph, but none of them have access to each other. So every single one of those is subject to copyright, even though they're all kind of functionally the same. So it is necessary to prove that the defendants had access to the work, because even if they produced somehow the exact same work, if they didn't have access to your work, it's not infringement. It's just one of those weird coincidences. So arguing they had access is kind of important. So you didn't allege that, so that's a problem. Plaintiff does not allege a substantial similarity between the lyrics, which also is a problem, because what are you complaining about? Plaintiff's lyrics constitute short, unoriginal phrases over which plaintiff cannot assert infringement. So there are no copyright interest in the individual phrases. Plaintiff does not allege specific facts against individual defendants, which, how are these people responsible for what things? As outlined below, the court finds the complaint does not state a copyright infringement of the plaintiff's lyrics. Pussy so wet, got the N-word wildin'. Pussy so wet, got the N-word wildin'. So that is not an infringing lyric. The Copyright Act provides the owner of a copyrighted work with exclusive rights to reproduce, perform, publicly, display, publicly, prepare derivative works, and distribute copies of a copyright work. To prevail on a claim of copyright infringement, the plaintiff must show ownership of a valid copyright. Copying of constitutes elements of the work that are original. So you have to have a copyright, and what has copied has to be something that you created. So if you compiled some stuff that wasn't yours, the compilation may be copyrighted, but not the elements inside, right? So as to give an example, if I sung the song Happy Birthday, the song Happy Birthday is outside of copyright. So you can't use my copy of it, but you still can use the underlying thing, because I don't have a copy to the underlying thing. So I can only have copyright protection for the stuff that I created, so not the original work. For the purposes of a motion to dismiss, defendant does not contest that plaintiff owes a valid copyright for Grab 'em by the Pussy. To prove the second element of copyright infringement, a plaintiff must show the defendant actually copied the work and that such copying was illegal because substantial similarity exists between the infringing work and the protectable elements of the copyrighted work. So you actually did a copy and that they are similar. Because if you copied without them being similar, then you didn't commit copyright infringement, right? Because you changed it so much that, it's a new original work at that point. So, fair enough. All right, as to access, plaintiff must show defendants actually copied the work. Actual copying can be shown through direct evidence of copying or circumstantial evidence defendant had access to plaintiff's work. Here, because plaintiff has not alleged direct evidence of copying, she must allege circumstantial evidence of copying through either a particular chain of events by which the defendant might have gained access to the work, or facts showing the plaintiff's work was widely disseminated such that access might be inferred. So how did they come into the possession of this song? Right? How did they come into possession of this song? Because if they didn't, they can't copy it. Here, plaintiff alleges that their ex-business partner, Matthew Thorpe, who was allegedly defendant Thorpe's father, was motivated to retaliate against her after the court sided with the plaintiff in a dispute involving independent living business. She also alleges defendants knew that Grab 'em by the Pussy was published on BMI and ASCAP. The court finds plaintiff has not adequately alleged access. As an initial matter, the circumstances alleged connection between Thorpe and plaintiff's ex-business partner does not meet the threshold of plausibility to allege that Matthew Thorpe was familiar with plaintiff's music, because that wasn't the nature of their business. Remember, they had some sort of interior design company or something. So, plaintiff was involved with Thorpe, the husband or the father, in some sort of interior design whatever, which doesn't suggest that Thorpe was necessarily aware of the plaintiff's music, because that wasn't the nature of their business, nor the nature of his business in general. He's not a musician. His daughter is, but he's not a musician. He's like an interior designer. So it's like, okay, so you haven't alleged that he's familiar with the music and therefore shared it with any of the defendants, especially when plaintiff's independent living business seemingly bears no connection to the musical career. Right. These two things don't seem to really be related. So how do you get from he was mad at me about, the business going south and me winning in court to he was aware of my music, shared it with the defendant, and the defendant decided to purposely rip me off as part of a revenge fantasy? It's a little thin. Yeah. Nor does plaintiff allege facts showing that grab 'em by the pussy was widely disseminated. So, it wasn't exactly a hit. She merely alleges in conclusory fashion the defense were aware of it, but they don't actually provide any facts to that end. So your work was published by BMI and ASCAP, but so are a lot of things. There's a lot of music out there, so yeah. On the other hand, the court notes that plaintiff embedded a link to Grab 'em by the Pussy on Spotify in her opposition to motion to dismiss, arguing her songs are available all over the work on all streaming platforms such as iTunes, Spotify, Apple Music, Tidal, and basically every streaming platform and record store that's available digitally. Should we listen to some of Grab 'em by the Pussy in the interest of trying to understand this lawsuit? We could do a fair use analysis of the song. See what the song Grab 'em by the Pussy sounds like. Do you guys want to listen to Grab 'em by the Pussy? Okay, I don't know. Anyways, however, even if the court were to consider these additional unpled factual assertions, plaintiff has not alleged when Grab 'em by the Pussy was made available on these websites, so it's unclear from the plaintiffs whether they're available on Spotify prior to the release of Wet Ass Pussy. So you didn't say when they became available. You didn't say when they became available. Even if the court were to credit these unpled assertions for reasons set forth below, dismissal of plaintiff's claims is warranted because the court finds plaintiff lyrics are not protectable as a matter of law. So the lyrics are not, protectable because they're unoriginal, and also are not substantially similar. So you don't have a copyrighted work, and also there's no infringement. So that's nice. The court finds as a matter of law that short phrases over which plaintiffs seek copyright protection are not protectable. To qualify for copyright protection, a work must be original. Because songwriters must be free to borrow sayings and expressions from popular culture, the Second Circuit and circuits in this district have found that short and commonplace phrases are not protectable, even when used as the title or repeated lyrics of a song. So you can't take a common saying and make it copyrighted just because, you made a song around it. You can't copyright the saying. It wasn't yours. The fact that people like it in your version of it isn't going to do the trick. Yeah, I think at this point we do need a little bit of this music. So because this channel, because this is already very, very demonetized in every possible way, we will take our chances with the copyright fairy. And let's see, what are we looking for? Grab 'em by the pussy. Let's see, and I'm looking for, okay, how do I spell this exactly? I'm on the bottom of page 8. So how am I spelling this exactly? So I can find your work in all of its glory. Denise Jones? I honestly can't find it. That's how well it's going right now. I can't find it. So I guess we will not have it because I can't find the song. So we will press on. I guess it isn't particularly widely disseminated. All right, so we read that. The lyrics over which plaintiff asserts copyright protection are no more than common phrases employed frequently in popular culture and other hip-hop songs. The concept of using pussy so wet as a rhetorical device in a song is neither original nor unique to plaintiff, and in any event, copyright does not protect ideas or themes. Indeed, defendant has cited at least 3 examples of works predating Grab 'Em by the Pussy, which use similar lyrics, and apparently there's a footnote about where we can cite them from. Likewise, defendant has provided examples. We read that part. Likewise, defendant has provided examples of at least 3 songs predating Grab 'Em by the Pussy, which use some variation of the phrase N-words wildin'. When only similarity between 2 works is not original to the author, a plaintiff's work is not protected by copyright and therefore is subject to dismissal. The court also finds the complaint fails to state a claim of copyright infringement because the lyrics at issue are not substantially similar. The basic tenet of copyright infringement claims is plaintiff's allegation the defendant's work or product is substantially similar to his or her own protected work. District courts in this circuit may evaluate a question of substantial similarity at a motion to dismiss stage under Rule 12. So you can determine it as a matter of law if it can be determined. So you can do substantial similarity because you're asking an ultimate legal question. So you're taking their facts as true. Here are my lyrics, here are their lyrics, and therefore making the legal conclusion as to whether they're substantially similar or not. When evaluating substantial similarity on a motion to dismiss, no discovery or fact-finding is typically necessary because all that's required is a comparison of the works, which the court can do. Here is work A, here is work B. Are they substantially similar or not? It's a legal determination. To determine whether 2 works are substantially similar, the court looks to whether the ordinary observer, unless he set out to detect disparity, would be disposed to overlook them and regard the aesthetic as the same. So with the ordinary, prudent, normal observer, the man on the bus, unless he was set out to detect disparity, would overlook the disparity. So, with the reasonably prudent consumer, not out on a quest to look for differences, just as a superficial way, say, these are the same thing. All right, that makes sense. In other words, the court examines whether an average listener would recognize the alleged copy as being appropriated from the copyrighted work. Additionally, 2 works are not substantially similar as a matter of law if the similarity between the 2 works only concerns the non-copyrightable. Because again, you don't have a copyright, and that is which is not copyrightable, so there is no copyright to you. And right about now, I'd like to remind A&E that they can drop their copyright claim against me anytime because they don't have a copyright in the body cam footage from the Sarasota police office that they are currently trying to seek copyright on for my channel because they aren't the creators of it, right? Their content where they filmed the thing, is not infringing because I use the same underlying content and they don't have a copyright in it, so there's no infringement. So yeah. Plaintiff's lyrics and defendant's lyrics are different. The lyrics got the N-word wildin', and why you at the club with N-word are not substantially similar. I mean, I'm not exactly a connoisseur of the rap. This may come as a surprise to you that I'm not, the biggest connoisseur of the rap. I do like Rapper's Delight, and I do like some Eminem and, Hoes in the House and all the rest of it. But not exactly the most up-to-date on all my hip-hop. But I do have to concede that I also agree that got the N-word wildin' and why you at the club with N-word wildin', not exactly the same thing. Those are very, very different things. Although both phrases contain the word N-word and wildin', plaintiff uses the singular form while defendants use the plural. Indeed, the phrase is actually used in 2 separate and distinct contexts. Defendant's lyrics, why you at the club with N's wildin', poses a question to the rapper, while plaintiff's lyric refers to rapper's effect on a single individual. You gotta love the deconstructive effort of a federal court, right? You gotta love the deconstruction of the rap and how one is posing a question while other is making a statement, right? One's saying I got that person doing it. The other one's saying, why are you in it, right? One poses a question. One is making a statement. They're totally different. The deconstructive efforts over here are real. Thus, the phrase is used in different ways and has different meanings such, the ordinary listener would not identify defendant's lyrics as being appropriated from plaintiff's song. Likewise, defendant's wet-ass pussy lyrics are not substantially similar to plaintiff's lyrics from Grab 'Em by the Pussy. While plaintiff repeats the lyrics, pussy so wet, got the N-word wildin', Twice at the end of her second verse, wet ass pussy repeats a different lyric, wet ass pussy, throughout the song as its hook. The lyrics do not share the shared pattern of words, nor are they repeated through the respective songs in the same manner. Again, a listener would not identify the lyrics as having been appropriated. So that's their view of the reasonable, prudent person. And then this is the fun part of the analysis where we get to do a lyric by lyric comparison between the two songs, so buckle up. As to other lyrics, finally, the court also finds that plaintiff has not alleged a valid copyright claim over additional unpled lyrics appended to her opposition to dismiss. Although the court need not review unpled new factual assertions contained in opposition to a motion to dismiss, in light of the plaintiff's pro se status, the court will review additionally alleged infringing statements since defendant has had an opportunity to respond to these in the reply. Plaintiff alleges the following lyrics also constitute copyright infringement. The plaintiff's lyrics from the song Bag. Why is she so savage, bitch? They have me gated in Northview, is apparently infringing from the song Savage, Ratchet, Boo, Bad. Which, I'm not really sure I see that, but okay. In plaintiff's version, F the Police, is apparently infringing from the song Girls in the Hood, in an unspecified way. The plaintiff's song, Bad Song, says, I'm at a vet with this shit. All I know is I'm eating dinner. From the West Coast or East Coast, all the bosses fuck with me, is apparently infringing of the song Don't Stop, Real N-Words, Love Me, from the H to the D. Again, I have to say that I don't think these lyrics seem very reminiscent of one another, but maybe it's just me. From the song Rich Chick Shit, either sign the disclosure or do not get in the party. Killers all around me, man. I'm not just anybody, is apparently infringing of the song Body. Body, Audi, Audi. Rule number 1, if we link up on Real, sneak tip, rule number 1, don't you repeat that. Shh. I don't really see the similarity in these things at all. From the song Money in Hand. Don't make me get in my bag. I get straight to the bag. Put the money in my hand. Every time I make the right, they want to bang the left. Is apparently infringing of Untitled. I be in my bag, but I be in his bag too. Okay. The song entitled Left Right is apparently infringing from a song called Simon Says, which contains the lyric left, right, left, right, left. No one before you ever thought to say left and right. Wow. From the song Grab 'Em by the Pussy, the lyric Got a Lil Whiskey and I'm Talking M. Lewinsky is apparently infringing from the Thought Shit, where the lyric hit Got a Bitch Get Toxic, drinking out the MTF bottle on my thought shit. Yeah, okay. From Grab 'Em by the Pussy, the lyric No Missionary N-Word Hit a Doggy Style is apparently infringing the song Thought Shit, Missionary or Doggy Style, I'm Top Shit, which seems very contradictory. I mean, the one person is saying they won't do missionary. The other person is saying missionary is just fine. I like it either way. So it's very different songs. From the song Rich Chick Shit, N-Word, I'm the shit, don't give an F who talk about me, is apparently infringing verses Thought Shits, don't give an F who talk behind my back, I don't give a F about a broad trying to bash me, I'm the shit. From the song Grab 'Em by the Pussy, don't come approaching unless you coming, talking about them thousands, is apparently infringing verses Thought Shits, we ain't even speaking if an N-word ain't spending. Those two lyrics have nothing to do with one another. It's just. From the song On You, VVS, All on My Necklace, N-Words, What's on You, is apparently infringing versus Thought Shits. Love when an N-word got a mouthful of VVS. My chain ain't hitting if a bitch ain't hurting. And there is a footnote, fortunately, that explains that according to Urban Dictionary, VVS is an acronym that stands for very, very slight inclusions when referring to the clarity and quality of a diamond. So it's an industry trade term for diamonds. So, you didn't come up with that so much as the diamond industry did. So, okay. From the song Bag, I'm a vet with this shit. All I know is I'm eating dinner is apparently infringing versus I'm a snake. I got lots of venom. Since these hoes all rat, all I see is lot of dinner. If you can understand how those two lyrics have anything to do with each other, you apparently are smarter than the defendants and also the court because we can't see any similarities. From the song Rich Chick Shit, I'm a bossy ass chick, like that sloppy toppy. You can just give me some head. I ain't trying to catch a body, is apparently infringing against Thought Shits, booked, but I squeeze a little head in my calendar. And from the song Grab 'Em by the Pussy, I could make him eat it while he do donuts. When it's time for court, nobody shows up, is apparently infringing against put this pussy in your face, swipe your nose like a credit card, hop on top, I want to ride, your honor, I'm a freak, bitch, handcuffs, leashes. Beside the fact that plaintiff has not alleged that she's a registered valid copyright over these works, as well as plaintiff's other lyrics, she cannot assert copyright protection over short, common phrases or words. The vast majority of these lyrics only share one or two words in common. For example, lyric 1 shares the word savage, lyric 5 shares the word bag, lyric 6 shares the words left and right, lyric 8 shares the words missionary and doggy style, lyrics 11 shares the acronym VVS, and lyric 13 shares the word head. These words are common in popular culture and frequently used in hip-hop, and such words are far too brief, uncommon, and unoriginal to create any exclusive right vested into the plaintiff. Nor can plaintiff assert copyright protection over the phrase in the hood, or over the fact that both she and defendant released remixes of Boys in the Hood. Plaintiff has not demonstrated any amount of creativity or original in these common words and short phrases sufficient for a claim of copyright infringement. The rest of the additional lyrics in plaintiff's opposition suggest at best that plaintiff and defendant wrote lyrics about similar concepts, although even I'm a little bit vague about that, to be quite honest. For example, plaintiff claims her lyrics from East or West Coast, all the bosses fuck with me, was infringed upon by defendant's lyrics, real N-words love me from the H to the D. What does H to the D mean? I'm trying to think what cities start with H and D. Is that from the hood to the downtown, or from the Houston to the Dallas? Anyone know what H and D are? While these lyrics might use a similar rhetorical device to demonstrate their rhetorical rapper widespread geographical appeal, they are in fact different sentences which communicate similar yet clearly different messages. Likewise, plaintiff also claims that her lyrics either sign the disclosure or don't get in the party. Killers all around me, man. I'm not just anybody was infringed by defendant's lyric. Rule number 1, if we link up on real sneak tip, rule number 1, don't you repeat that shit. Again, while both lyrics emphasize the importance of secrecy during encounters with their respective rappers, they are clearly different lyrics. Their only commonality is to communicate ideas about secrecy. These themes and concepts are neither unique nor original to plaintiff and not protectable under copyright. You guys are thinking Dallas to my hose place. Someone said Houston to Detroit. Yeah, I don't know what's going on here. You think it's head to dick? Well, the court refers to it as geographic. They talk about geographic appeal. So I assumed H to D was a geographic reference, or maybe the court's just confused and it's not a geographic reference. Maybe the court thought it was geographic. Okay. And also, not for nothing, but that like leaves half the man unaccounted for. I mean, those aren't really comparable. Like east to west coast kind of covers like everything. Head to dick. I mean, what about my legs? What about my 500-pound leg squat? Where's that respect? Why aren't my legs getting any love in this song? What am I, stumpy over here? This is some bullshit. Plaintiff's complaint suggests that they're also asserting claims for criminal copyright violations and for stalking and harassment. Do you know how hard it is to do a criminal copyright complaint? First, it's undisputed there's no private cause of action to enforce a criminal copyright complaint. Secondly, plaintiff's allegations regard for stalking and harassment, broadly construed as a claim for intentional or negligent infliction of emotional distress, are insufficient. For infliction of emotional distress under New York law, a plaintiff must allege extreme and outrageous conduct, intent to cause or disregard, substantial probability of causing severe emotional distress, and a causal connection between conduct and injury and severe emotional distress. Liability has been found only where the conduct has been so outrageous in character and so extreme in degree as to go beyond all possible bounds of decency and be regarded as atrocious and utterly intolerable in a civilized community. Here, plaintiff alleges in conclusory fashion the defendant stalked plaintiff's social media via Instagram and Facebook to gather content and information to use in videos as scare tactics. Plaintiff also claims that she was alarmed when defendant Pete announced that she intended to start her own independent living business known as Plaintiff, knowing that plaintiff had previously had her own independent living business, and Pete was trolling and bullying her the full time. So apparently, in addition to her rapping, she would also like to start some sort of interior design business for, I guess, people who want their houses to like have water flooding problems, as was demonstrated in that song Wet Ass Pussy, where they had some serious flooding issues. But if you'd like serious flooding issues in your home, I guess the defendants might be able to help. After plaintiff allegedly published defendant's alleged copyright infringement via social media, defendant heightened the harassment by using other major artists in the label and affiliates to troll and copy all content that Niecy X released to cause substantial emotional distress, suffering, anguish, humiliation, and fear of being singled out of the music industry. I don't think she's going to be making any friends as a result of this lawsuit, I'm just going to guess. She also alleges she was caused emotional distress when she realized defendants have named WAP after BAPS, which is like the most like 6 degrees of Kevin Bacon conspiracy theory I've ever heard of. You're telling me that Cardi B and Megan Thee Stallion called it Wet Ass Pussy because of WAP, because it sounds like BAPS, all in an effort to troll you. I mean, I've heard of rap beefs and all, but damn. Do we have a persecution complex or what? And also, the defendants copied her trademark hairstyle and expression to copy, annoy, and mock her. You know, when I looked for the song, I didn't look for it under her stage name. I looked at it under her real name. That might be the problem. What if I looked for it under her stage name? Yeah, Niecy X. Oh, yeah. Oh, we're there, people. We're there, people. You ready? All right. We're doing this. We're doing this for the sake of fair use and commentary. Okay. We're going to listen to a little bit of the song Grab 'Em by the Pussy by Nessie X and see what it has to share with us in all of its great glory. Let's listen to a little bit of this. This should be entertaining. That's not the right one.
You know, I'm automatically attracted to beautiful. I just start kissing them. It's like a magnet. You just kiss them. I don't even wait. And when you're a star, they let you do it. You can do anything. Whatever you want. Grab them by the pussy.
Grab that bitch by the pussy. I'm talking politics. I ain't talking to you rookie bitches, Mr. President. Can I talk to you for a minute? Got a little whiskey and I'm talking them Lewinsky. Free my niggas in the penitentiary. Only way is if we get up in the fucking system. Fuck the DA, fuck the judge, fuck the prison, fuck the police. Make him pull out his pistol. I can make him eat it while he do donuts. And when it's time for court, nobody show up. It's power in the pussy, power in the pussy. I ain't no rookie, so like the president, I let him grab me by the pussy.
All right, so in the interest of fair use and commentary, I'd like to suggest the following musical critique. I found the beat very generic, lackluster, and very unpersuasive. I found her voice to be somewhat drowned out in the mix, so I don't really like whoever did the mix on this, because her voice, at least to my ear, doesn't really stand out very well versus the beats, especially like that bass line. It feels very overpowering versus the mix. So like the beat is too strong and clouds out her voice. Also, her voice is a little whiny. Is a little whiny and kind of pleady and not particularly strong. I'm not sure she's projecting herself with very much confidence. She sounds almost like embarrassed by it. She doesn't feel like she's really delivering it, with gusto. It feels like she's a little bit ashamed of herself, and she's not really delivering it with clarity. And perhaps the beat and mix has been deliberately emphasized in order to hide her weaknesses as a performance artist. Also, I can see why on Spotify she has a total of 2 monthly listeners. So this stream alone has, I don't even know, like times 50'd her entire monthly bandwidth. So I can see why she's not exactly, with the 2 monthly listeners, the idea that, Cardi B and Megan Thee Stallion were copying her, I'm not really feeling it. So I don't really like the way this is arranged. I find her lyrics and arrangement very banal. I find the mix very overproduced. I find her delivery of the song very delicious. Her lyrics are very generic and don't really speak to an individual personality, feel very basic, and feel like someone who's a little try-hard. This musical critique has been provided for the purposes of fair use. She also alleges that she was caused emotional distress when she realized about the WAPs versus BAPs thing. These conclusory and unspecified allegations are insufficient to allege intentional infliction of emotional distress. New York sets a high threshold for conduct that is extreme and outrageous enough to constitute intentional infliction of emotional distress. The conduct in question must be so outrageous in character and so extreme in degree as to go beyond all possible bounds of decency and be regarded as atrocious and utterly intolerable in a civilized community. At base, plaintiff alleges that she believes defendants stalked and harassed her by continuing to mime her social media and music for more content to use for defendant's song. Knowing and purposeful copyright infringement does not rise to the level of extreme and outrageous that New York courts contemplate to sustain another intentional infliction of emotional distress claim. Plaintiff does not allege defendants used social media to threaten, verbally abuse, intimidate, or hurt her, conduct which could have risen to the level of intentional infliction or emotional distress. Plaintiff's other allegations the defendant caused her emotional distress by naming WAP after BAPs, copying her trademark hairstyle, which, okay, not really. I'm looking at a photo of her on Spotify, and I have to tell you I don't see the similarity, really. but that's just me. And defendant Pete announcing she wanted to open a similar type of business as plaintiff do not rise to the level of extreme and outrageous behavior. Yeah, that's a weird one. I'm going to open up a business that's similar to yours, and that's extreme harassment. The complaint also fails to state a claim of negligent infliction of emotional distress. For negligent infliction of emotional distress, a plaintiff may recover under either bystander theory or direct duty theory. The bystander theory requires plaintiff to allege that she has witnessed the death or serious bodily injury of a member of her immediate family. As is more relevant here, the direct duty theory requires plaintiff to allege she suffered an emotional injury from defendant's breach of duty, which unreasonably endangered her own physical safety or caused her to fear for her physical safety. Because plaintiff does not allege a direct owed duty to defendants to plaintiff, the allegations are insufficient to state a claim of negligent infliction of emotional distress under direct duty. The duty in such cases must be specific to plaintiff, not some amorphous, free-floating duty to society. So yeah, you can't sue someone for breach of a duty unless they actually have a duty to you, and they have no duty to you. So no, it's not so much. In her opposition to motion dismissed, plaintiff makes generalized allegations about fearing for her safety from alleged stalking and harassment by the cartel she equates to the music industry at large, based, but plaintiff neither identifies any negligent conduct on part of the defendant or any special duty to avoid causing distress. In fact, plaintiff does not allege any sort of relationship between her and defendants that could give rise to the duty. Accordingly, any such claim for negligent infliction of emotional distress is also dismissed. Generally, courts grant pro se applicants an opportunity to amend to cure. However, leave is not required when it would be futile. Here, granting plaintiff leave to amend would be futile because finding a lack of substantial similarity turns on the words themselves and not the artfulness of the pleading. So, I actually reviewed it on the merits because I actually looked at the two things. And we, too, have also looked at the merits in reading the words and, unfortunately, by listening to the music, which we are now all painfully aware of on levels. So, so we too have considered the merits, and I'm not seeing a lot of similarity between these two works. I have to be honest, once again, I am not exactly a rap connoisseur, but nothing about that song says to me, oh yeah, this song and Wet Ass Pussy, it's like I'm listening to the same song twice. I listened to this song, and I listened to Wet Ass Pussy, and man, there's just so much similarity. It's like I'm hearing double. She could tell me that she thought that Dust in the Wind by Kansas was infringing her, and it would have about as much similarity as Wet Ass Pussy does. Because I'm not hearing it. Thus, because amendment would be futile, complaint is dismissed with prejudice. Amendment of plaintiff state law claims would also be futile. Plaintiff has failed to plausibly allege claims of negligent or intentional infliction of emotional distress because she does not allege any extreme or outrageous conduct or defense over a special or direct duty to avoid causing harm. Thus, it's dismissed in prejudice with the entirety and go away. And that is the entirety of this stupid. That is the entirety of this stupid. So, yeah. Yeah, so. That's all. All right. As long as you guys are here, I'll share with you this video of this girl being the most entitled girl ever and just getting wrecked by the police. I was covering it with Artie a little bit on his channel, and it's been making the rounds a little bit because of how hilarious it is. Let's see, where is this thing? Well, I have to find this. I hate it when I try to find stuff on the fly because then I look like an idiot because I can't find everything right away. Okay. This looks promising. I think I got a link from Reddit. Okay, yeah, I got it. All right, hold on. We have to rearrange the thing. All right, that's good. All right, so this is from YouTube. Entitled Daughter Loses It When Finally Told No. Entitled Daughter Loses It When Finally Told No. This one was good. So let's watch this and comment on this pile of stupid.
On September 18th, 2022, police were called about a daughter refusing to leave her father's car.
Okay. Why isn't she getting out?
I don't know. She's got a lot of problems in life and can't seem to solve them. So I offered to give her a ride, and now...
This is my dad, and I think he's, I don't know exactly what's going on, but he has the key to the car, so I'm just waiting on him to get out of the building.
You're waiting on him to what?
To get out of the building, to come drive the car. He just parked us here, so I don't know.
Yeah, but you know he doesn't have to drive you anywhere. But it's his car. He doesn't have to take you anywhere if he doesn't want to.
I understand. Well, he already took me here, so I'm in the car. I'd like to, go back to my house whenever he's ready, basically. So I'm just sitting in the car.
Okay, but do you realize that if he doesn't want to take you, you have to get out because it's his car, it's his property?
I don't think so. I think
no,
I'm
letting you know that that's how that works.
Yeah, I do think that's kind of how that works. I think that's exactly how it works. I like her. She's like, do you realize that, if he doesn't want to get you anywhere, you have to leave the car? No, I'm not. I don't think that's how it works. Yeah, I kind of think it's how it works. I kind of think that's how it works. All right, yeah, it's going great.
Okay, well, I'm going to be sitting here. So, whenever he's ready.
But he doesn't want to drive. You don't want to drive her home?
No, I do not.
I think he might be having some sort of like early dementia or something, but he is not acting like himself.
Early dementia. She says, I think he might be having early dementia. I'm like, lady, I listened to him as the cop was calling up. He is perfectly 100% lucid. He might be having early dementia. No, he is incredibly lucid. He understands exactly what's happening. He understands what's happening on levels. He understands it like the Matrix. He's got depth. He's got levels of understanding. He understands it on every possible level. He's got dementia. It's such a gaslighting line. What a horrible little girl this is. What a pain in the ass.
We were just going to go to Starbucks, and then he said that he had to go, and I can't remember if he said he needed to take a package somewhere.
He had me bring her down here. I got her a couple of gift cards because she doesn't have a job.
He did. He just got me a gift card.
She's supposed to be in a rehab facility, but somehow managed to get kicked out of it and showed up back at the apartment. So I felt sorry for her, my mistake. Gave her more money, gave her more things to do, took her here so she could get food. Not only did
Does he sound like a person that has Alzheimer's or dementia? Does he sound like a person that doesn't understand what's going on? Nope, sounds pretty coherent to me. Seems like he's pretty coherent. He's telling a perfectly logical, coherent story that flows in a very orderly and well-organized way. It's like he's completely lucid. Yeah, I'm not seeing the Alzheimer's dementia. He sounds okay to me.
she not get food, she refused to get out of the car, and now she refuses to get out of it at all.
I'm just trying to spend the day with him.
Sorry,
or like go out and run errands. We're just trying to run errands.
You said she was evicted from the apartment. Does she not so that's not where she lives anymore?
I still live there.
She is in the process of eviction. I don't think they got a final order for it yet.
Okay.
So she can still be there. But
It doesn't really matter either way.
It doesn't really matter either way. It really doesn't matter either way. I'm not even sure why the police asked the question. So I think that was daughter who said it doesn't matter either way. She's right. It doesn't matter either way. It doesn't matter whether you have anywhere else to go or not. This is his car. You can't be there right now. So, get out. So, I'm not sure why the cop necessarily asked the question. It doesn't matter either way, but okay.
I live normally. I'm not trying to live in this car. You know what I mean? So.
Yeah, but you're not trying to get out of this car.
Correct.
Which right now you're
now.
breaking the law because it's not your car. So you're trespassing.
So I go on Ubers.
Okay.
Ubers
With the permission of the person. He does not want you in his car.
Yeah, see, that's the key. That's the key. Yes, you go on Ubers with the permission of the person. The cops got it exactly right? When you get into an Uber, it's because you have permission. And then they tell you to get out of the car and you no longer have permission. Right. Yes, you get into Ubers all the time. He is not an Uber. And even if he was, he wants you out of his car. So, take it up with Uber, I guess. But, it's neither here nor there.
You're trespassing in his okay, so
I just love it. No, I'm not. No, I'm not trespassing. You're. This is trespassing. This is trespassing. You are in his property without permission. That would be what trespassing is. And he wants you to leave, and you weren't leaving. So, could be trespass.
we can play this game, but you're gonna get arrested. I mean, that's literally how it's gonna be, or you could just step out of the car. Like, I'm not trying to be mean to you, but I'm trying to explain something to you, and you're not really willing to listen.
You explained it to me, but I would like to shut my door now.
I'm not doing that. It's not your door. It's not your car.
Okay, I'll just ignore that then.
Just get out, Alex. You're making a show
His
out of
door?
this.
I'm not trying to. I'm not trying to make a show out of it. It's just like, it's frustrating.
See the problem. I didn't want to touch her at this point. Because
No, I understand. I mean, it's definitely your car, and you want her out of the car. Can you understand?
I shouldn't have agreed to do it. She's had long-term
6528.
enabling this bad behavior, and it's my fault. I enabled one more time.
So it's not your car. If you want to out, you're trespassing. You gotta get out.
Well, I think there's a misunderstanding. I think something's going on with my dad because he's not acting like himself.
No, he's acting pretty normal to me.
No, I think
I agree with the cop. I think Dad's acting quite normal. Dad is quite calm and lucid and quite clear, and it's his car. And so, I agree. I agree with cop over here. Between the two of you, Dad is definitely the more lucid of the two of you. Dad understands reality. Your understanding of reality is less established than your father's at this point. So between the two of you, as to who's more lucid.
he's acting like he's got a problem.
No, he's good.
Maybe like he has early onset like dementia, Alzheimer's.
Can we talk outside
of
this
No. You guys are right here. I'm fine. I'm not stepping out. And I feel like usually you ask people not to step out of the car.
Why won't you get out? Why don't you want to get out?
It's on principle at this point. But
But you understand that you're probably going to end up going to jail then, right?
you do know that usually, like, if you pulled me over on a highway, we'd both have to pull over, park together.
We're not doing
And
that.
I would not be allowed out of my vehicle, in fact.
Well, it depends what the police want to do in terms of whether or not they're going to have you step out of the car or not, right? If the police want you to stay in the car, you stay in the car. If the police want you to exit the car, you exit the car. There's a case called Mims from the U.S. Supreme Court, by the way, exactly on point. The cops have the right to have you step out of the car if they want for absolutely no particular reason whatsoever. They don't need any justification. They can do it as part of a routine standard traffic stop if they want. Now, if they are extending your time of detention, you might run into a different wall with a different case. But like for their own safety, if they want you to step out of the car and it doesn't like unduly extend the period of the stop, then yeah. So, and if they want you to stay in the car, yeah. So she's like, well, if this was a traffic stop, you'd have me stay in the car. Maybe, maybe not. But either way, what does that have to do with anything? This isn't a traffic stop. You're trespassing. So
They roll down the window and please present your papers to me. That's what you would say. And I would give
But
you
I
that
may.
information.
Sometimes I also
Stay in
ask a lot of people out of the car too.
Okay, well, this isn't.
But your dad wants you out of the
This
car.
doesn't feel like a very real situation. Like, and it doesn't feel like we're bothering anyone.
So do you want to press charges for trespassing?
I do.
I mean, you can't just press charges like that.
You can.
I mean, she's kind of technically correct that he can't just press charges like that. Technically speaking, it's not up to him. Whether to press charges or not, technically, of course, it's up to the prosecutor as to whether or not press charges or not, but he's basically saying, yes, I'm a complaining witness. Not incidentally that we need him at this point, because the police are literally watching the crime be committed before their very eyes. They're literally watching the crime in progress happen as we speak. So we don't even need him as a complaining witness at this point. So I guess technically correct is the best kind of correct. Yes, strictly speaking, he can't press charges like that. But for the purposes of the exercise, he kind of can. So, half credit from the legal scholar, but I don't think she's saying it because she's a legal scholar. I'm not getting it that she's saying it because, well, actually, technically, he can't press charges because that's not technically something he can do. I'm not getting a lot of legal analysis vibes from her.
No, you can't.
So do you want to get out of the car or not?
Don't you guys have anything better to do today?
We actually do.
Yeah, so I don't know why.
I love that line from the cop. I love that line so much. Don't you have anything better to do? Yes. Yes, I do. I love that line just because it's so honest. Yes, I have better things to do. Please step out. I could be eating a donut. I could be drinking coffee. I could be looking at a bird right about now. Anything would be better than this bullshit.
I really like for you to get out so we don't have to. I don't want to take a ride to the jail.
I would love to.
I would hate that.
You know what? I love riding around places. I love going on errands. I love driving. Love all of it.
This is going to be one of those situations on when you go down to the jail. People are like, "What are you in for?" And you say, "Because I wouldn't get out of the car." People are going to be like, "That's a stupid reason to go to jail." I mean, really, there's really not a really good reason to go to jail, but that's really stupid.
Well, it's more stupid of you guys because it's just a lot of paperwork and a lot of trouble.
We don't want to be here, but we're public servants. We've been called here.
You're not a servant.
We've been summoned here, so we're here to solve a problem. Unfortunately,
Do you have a payroll?
the problem is that you're in the car. It's to solve the problem.
I don't think there's not a solution. There isn't a solution.
The solution is that you step out, either stand over here, you could sit, there's a bench over here, there's a bench there, there's a bench over there. Okay, yeah, go ahead and stand out of the car.
No, I stepped out. It's fine. Please allow me to.
No, you're not
my
closing the door, so...
I don't want to shut it on you. I don't want to,
I can promise you you're not.
Please stop touching this car because it's not your car.
It's not yours either.
Well, that's okay.
All right, you're going to end up...
No.
You're going to end up...
You are. Stop. Step on out. I'm just going to pull you out. I mean, at the end of the day, you're going to come out of the car, so do we have to make this harder? I don't want to.
Don't pull my arm out of its socket.
Please step out.
Don't touch me.
We'll just get the statement. We're not in a hurry.
Okay. Don't touch me. Don't molest me. Please.
What's going to end up...
Don't molest me, she says. Don't molest me, she says. Well, Dad is hero. Dad is my hero. I love Dad. This woman needs to be told no in a very, very serious way. Don't molest me, she says. Yeah.
What's happening is we're going to end up having to use force on you.
I would like to press charges for assault. An assault charge. I just was assaulted. Battery.
So
I want to press charges for battery.
Not for nothing, but the police, of course, can use force. And in fact, for that situation, technically speaking, he could too, although obviously puts him at greater risk. But technically speaking, he can use force to eject her from the property like a bouncer would, right? So it's like we can help you along. But of course, that can lead to a whole bunch of nastier situations for him. But it's like, oh, I want to press charges for assault. I want to press charges for battery. It's like, no, you're not complying with a lawful order. The lawful order to exit. You're trespassing. We're now going to use the force escalation tree. We tried the verbal commands, right? So let's move up the force escalation chart. Force escalation chart time.
I want to press charges.
it's a lawful...
No.
I would like to press charges.
Not a chance.
I'm being held against my will.
Great, get out of the car.
No, I'm being held against my will. Please leave.
No. So
You're
these are
being
the
held
actions. You
against
can
your
get out of
will.
the car. You can leave on your own accord. You can walk away.
I'm being
or
held
you can end
against
up
my
going with
will.
us.
This is the worst version of I'm being held against my will ever. You are literally free to get out of the car. In fact, we'd very much like you to get out of the car. This is the very opposite of I'm being held against my will. That is so hilarious. I'm being held against my will. Where should just learn these stock phrases?
Or something. I don't know what else to tell you. get a judge and a jury and take me to trial. Like, I don't really understand.
That's probably going to happen.
Mail me some papers. I mean, I don't know. Like,
Would you like to be married?
whatever the charges are, like, let me know.
Right now,
are you going to give me a ticket? Why don't you just give me a ticket?
Well, you're committing an arrestable offense. You're committing 2 arrestable offenses. Failure to obey a lawful order, because the order was lawful. Trespass. And also resisting, technically. So we got 3. So, yeah.
Oh, that's the problem. So the main
Or a verbal warning? Be like, hey, please don't sit in people's cars again if they don't want you in them.
so that
We tried the verbal warning approach.
No, you didn't. But anyway, my dad is obviously like demented, and he's got like
You're
an issue
demented.
that I can't diagnose, right? I don't know what to do because he's getting older. Yes, in fact, we live at the same building.
Okay.
I am his caretaker. So
You're his
You're his
caretaker?
caretaker.
Yes, I am.
Okay.
And you know what?
How do you care for him?
I take care of him.
How?
I'm his caretaker. I take care of him. Yeah, you look like a professional caretaker. You definitely look like someone who's trained to care for somebody. Yeah.
I take care of him.
You work?
Yes, I do. I work a lot. I do things. It doesn't matter. What do you do?
You sound a lot like my brother used to sound before he burned my mom's house down.
What do you do? You just like police stuff? What is that? What is policing?
That is literally my job.
That is my job. Yeah, you got it. I literally police things. I literally police things in a police kind of way. That's what I do. That is my job. I police things. It's going great.
A supervisor. But here's the issue. Your father is wanting you out of the car. He's willing to press charges. Therefore, you're going to end up going with us because you're refusing to get out of the car. I literally cannot be nicer to you.
It's like, what if you were in my doorway at my house and like you were holding it?
Different scenario, different rules, different times, different things.
Yeah.
This isn't your car.
Is that your street?
It's part of the city.
Is that your pavement?
It's the city's.
Or is just that your stone?
It's the city's.
Okay, the city.
Why
Okay, in the
don't you
brick.
want to get out of the car?
Who runs the city? Who owns the pavement? I want to talk to
city
whoever
does.
owns the road.
Who do you think that would be?
I don't know. I think you would have to try to get in contact with them or something.
I don't have to do anything.
I don't know. Talk to the bank that like rents out that pavement. I don't know what to tell you. Call someone. But it'd be really cool if you would just let me shut the door. I'm not a dog dying in a hot car, okay?
You go by Alex Alexander or you go by?
What am I called?
Yeah, what do you go by? Do you like to be called Alex Alexander?
I don't like to be called at all.
You know what?
I don't like to be called at all.
Okay, what is your name?
Do you want to put where you see your daughter?
Why do you need to know that?
All right, Alexandria. I'm again going to politely ask you to get out of the car.
I would tell you my name if I wanted to.
Things are going to go not your way in a minute.
I don't have them.
And I would prefer them not go down that way. Yeah, but they're going to get worse.
That way.
They're going to get
Which way
worse.
that way?
Because what's going to end up happening is you're going to get forcefully taken out of the car, and I don't want to do that.
Whatever.
The police are trying so hard. They are trying so hard not to arrest you. They are trying so hard not to arrest you. Have you ever seen someone try harder to get arrested than this girl? They are trying so hard not to arrest you. They want any other solution than this.
Because I don't want us to get hurt, and I don't want you to get hurt. So I really would like you to get out of the car so that we don't have to force you to get out of the car, or that force doesn't have to be used.
Defiance.
That's your choice?
Defiance.
So you understand the risk that you're taking with this, right? Okay.
All right, let's do it the hard way.
You're insulting me. What are you doing?
Arresting you.
All right, put your hands
No, I'm not going to. Why?
Put your hands behind your back.
No.
You're under arrest.
No.
You're gonna be
I'm
facing
not under arrest.
You
I'm
are.
under cardiac arrest, if anything.
I'm under cardiac arrest. I'm under cardiac arrest. I'm not under arrest. I didn't know no, I'm not under arrest was an option. I mean, I've been a lawyer for 15 years and I didn't know that no, I'm not under arrest. You know, I'm rubber, you're glue was an option. I missed that memo in law school somehow.
No.
You're placed under arrest for trespassing and resisting.
You can't do that.
We can.
They really
No,
can.
You're not going to.
They really are.
You're not going to.
They are doing that as we speak.
Stop.
I wish we didn't have to.
Stop.
I wish we didn't have
Stop.
to. We tried to work it out with you.
Stop.
And for whatever reason, you decided
Stop.
not to.
Stop policing me.
Bye, Alex.
Stop, please. And then you heard Dad just say, bye, Alex. Did you hear that in the background where he just says, bye, Alex? Did you get that? I wanted to make sure that we don't let that moment go by, because it was a nice one.
For whatever reason, you decided
Stop.
not to.
Stop policing me.
Bye, Alex.
I'm sorry that this is the way that it had to go.
This is not the law.
It really
This
is.
is lawful.
No, pretty lawful.
Alright. I'm not resisting. No, stop searching me. Stop touching me. I have to search you. You're molesting me. You're sexually assaulting me.
Stop.
You are sexually assaulting me. No.
She's not.
Yes, she
No, she's
is.
not.
Dad, help me.
I am not helping you.
Please help me. Please help me.
Stop.
Get off me.
Stop.
Get off me. Stop.
Resisting. Now you're getting a felony.
You have violated the law.
Get
Yeah,
off
now
me.
you're-
Stop touching me.
Now you're resisting, and now you're attacking the police. So you're moving into felony territory rapidly because you're attacking the police officers.
Stop resisting.
Stop touching me.
Stop resisting.
Stop touching me. He's mentally ill.
You're
Stop
mentally ill.
touching me. Oh, my arm.
Sit in the
Stop
car.
it.
Sit in the car.
Stop it.
Can you please pick up your knife and sit in the car? I don't want to have to help you.
He's like, I don't want to have to help you. Okay, now I'm going to help you.
Get off me. Stop touching me.
Close the door.
I can't listen.
I'm sorry. She may be under the influence. I'm so sorry.
You too?
Yes.
So we're going to charge you resisting. Okay. Listen, if you try to hurt us again, you're going to either end up getting tased.
Me hurt you? You guys were hurting me.
Okay. Well, you
You
kicked
guys
both
actually
of them.
assaulted me.
You kicked both of them.
You grabbed me and then she touched my breast for
here's
no
the-
reason.
Well,
So
She was
I don't
frisking
really,
you.
No.
You
So
take a
you
deep
touched
breath.
me inappropriately as well on my skin. You
Take
know
a
that you
deep
don't need to
breath.
contact me like that. I was in
Take a
handcuffs
deep
already.
breath and listen to what I'm telling
My
you.
hands were behind my back. So
Your
no, you
hands-
shouldn't have searched me like that. And I should have
didn't
gotten
search
searched
you.
private.
They can search you like that. It's a standard frisk. Even in cuffs, they will frisk you. You know, because people sometimes get out of cuffs. Or sometimes even in cuffs, they can reach in their pants and pull a knife, pull a gun, all kinds of weird shit. So, you know, the police are going to do a standard frisk when you get arrested. It's like, yeah, that's a search incident to arrest. That's, you know, no problem.
First of all, you should have not been out here, not with her and doing it. Second. And you're embarrassing me
We're
in
gonna
public.
open the door.
You're actually it's libel. It's a lot of libel.
Listen, you're embarrassing
We're
yourself.
going to
It's libel. It's libel. No. Just no. Just remember, my friends, it's not libel if it's true. So, yeah.
open the door. Okay. You're going to get put back in handcuffs. If you fight us,
Do you have a liability policy? Like, do you guys have some sort of commercial health
do
insurance?
not fight us, okay?
What are you so scared of? I don't want to give back my things. I want them. Why don't I get to keep them? No, don't touch me. See? You're touching me again. Stop it. Open the door for me. Stop touching me. I don't want to. No, what are
I
you
don't
doing
want to?
now? No, same thing we were doing before. We're just going back and forth. You're under arrest. Oh, Miranda rights. Miranda rights? No.
They don't need to read you Miranda because they're not asking you any questions. Miranda rights? Miranda rights. Miranda's something I've heard of. Where's my Miranda rights? They are not asking you any questions. They don't want to ask you any questions. Miranda is not a thing. Yeah.
You were resist?
You are resisting.
I'm resisting.
Yes, you are. So stop. You've already got battery on LEO. Stop.
On a Leo?
Yes.
On an August birthday?
You gotta love her turns of phrase. I got battery on a Leo on an August birthday. You gotta love her free association. You gotta love her creativity.
On a Leo? What? No. Get off me. I don't want to be handcuffed. I don't want to be tied down. Stop it.
Nobody really does want that.
You're constricting me.
A little bit, yes.
I can't breathe. You're constricting
fine.
me. You're not doing anything. You're hurting me. You are physically hurting me right now. My chest hurts, my head hurts, my hands hurt, my wrist hurts. I know it hurts.
Your wrist would hurt a lot less if you didn't pull at the handcuffs that were currently restraining you. Your wrist would hurt a lot less if you weren't trying to, like, you know, yeah.
My shoulder blades and my shoulders and my back, which is where all my organs are, by the way, so thank you. You would just cooperate. You're not cooperating. You are not cooperative. We are not a co-op. We are not a co-op. We are not a corporation. We are not a co-op. You're not a cop. You're not cooperating. You're not a co-op. We're not a co-op. We're not a corporation. You're not a cop. I mean, you know, I'll give her points for the free association thing. You know, she probably would like be good at like improv or something because she can do some like free association wordplay. So, you know, she probably has some good comic sensibilities in there somewhere if we could just, you know, harness her power. But, you know, it's like, oh, you're not cooperating. It's not a co-op. You're not a corporation. It's not a cop. I'm like, you know, there's something there we can work with. Let's go back and listen to it again because it was fun the first time. We are not a corporation. We are not a co-op. You're not cooperating. You are not cooperative. We are not a co-op. We are not a co-op. We are not a corporation. We are not a co-op. You're not a cop. You're a robber. You're stealing me. You're kidnapping me. You're abducting me. Ow!
I mean, we're seizing you, to be more constitutionally correct. We are seizing you, the person. Yeah.
Hurting me. No! Stop doing it.
Have a seat.
In the car without us fighting.
Sit back. Sit back.
You just sit down. None of this would happen. Get off me! You're creepy as you creeper! Alright,
She tried to bite you, by the way.
I know.
Pervert! Get me out of here! Get me out of here! Get me out! Let me out!
It's not happening, so.
Open the door! Open the door! Open it!
Can I go?
Florida woman is best woman. Only in Florida. Only in Florida.
Bring me to the hospital right now. I can't breathe. I'm too hot. I can't breathe. I'm gonna have a seizure.
I just turned the AC
I'm
up
going
for
on
you,
a
okay?
seizure.
You gotta give it a second. I just turned off the AC. You'll be able to get some air in a couple seconds, okay?
I need Bravo 2.
I don't know what that means.
Take me to the hospital. Take me to the ER. To the ED. Take me for medical clearance.
You'll get medical clearance at the jail.
No, they don't medically clear you.
Oh, they do.
No, they don't.
Absolutely.
No, they do not. They do an intake form. That's not the same. I need a physical exam. Who's the elected person in this jurisdiction? Take me to them. I don't even know that this is your jurisdiction.
She's doing a little sovereign citizen right now. Who's the alleged person in this jurisdiction? Take me to them. She's doing a little sovereign citizen over here. Don't go full sovereign citizen, people. It's not worth it.
Who you are. You're kidnapping me. Give me a ride. Give me a ride home. Turn the car around. Reverse. Reverse.
I just love that exasperated sigh from the cop. That just makes it all so worthwhile, that exasperated sigh. I feel you, police officer. I feel you. I want to be the judge of her case so bad. I want to be the judge of this woman's case so bad. I've never wanted to be a judge more than I want to right now. I want to be a trial judge in Florida and be like, yeah. So, yeah. Well, that's the end of the video. That's the end of the video. So, that is all there is to that. So, that was hilarious. That was hilarious. So what else can we cover since I've got you guys here for a while? What else can we do? Let's troll the story suggestion. Let's troll the story suggestions and see if you guys have any story suggestions that we guys could cover. Let's see. Yeah, it looks like the Trump case might be televised in Georgia, so that's exciting. Let's see what else we got. Microsoft exec's ex-wife was arrested for murder. Yeah. Columbia Law School halts requiring video statement from prospective students due to Supreme Court decision. I hadn't heard about this one. What was this from Columbia Law School? Columbia Law School no longer asks applicants to submit video statements after it faced accusations it was trying to circumvent the Supreme Court's ban on affirmative action. Nice. Axoltian gifted 10 gift memberships. Thank you very much. You can always pull a Joe and question science, but I know too much science. I know too much science and I respect science. Joe and science makes me sad. Joe's scientific discussions make me sad. They make me sad every single time. Jason Lulsey said, Kurt, you should read this with some background music with a little rap. This is crazy funny listening to. Love your work. Sandy gifted 10 gift memberships. Vixen has been a member for 9 months. Sandy has been a member for 11 months. Vixen gifted 20 gift memberships. And then it looks like gifted another 20 gift memberships. Summer Butterfly has been a member for 8 months. Extolian gifted 10 gift memberships. Andrew J. gave 10 Canadian dollars to say, Kurt reading lewd rap lyrics is giving me life. Here's for the demonetization fund. And $2 for we need to compare wet ass pussy to grab him by the pussy, which we definitely did. So what else do we want to talk about today? What else is on your mind? Do we just want to watch random cop videos? They're hit or miss. What's on your guys' mind in chat? What about Murdaugh losing his phone privileges? Yeah, that was pretty funny. So Murdaugh, as you guys well know, was convicted for the murder of his wife and son. And he circumvented phone privileges by using another prisoner's PIN number to make a call. And also by using his attorney to do an interview, which is prohibited by the jail's rules. They don't allow prisoners to do interviews with press. So his lawyer, he met with his lawyer, and his lawyer connected the phone call to the press, and they wrote the attorney a very chiding letter, basically say, don't do it ever again, because you're circumventing our jail's rules. And the purpose of the attorney-client meeting is to meet with the attorney. So if you go outside that purpose, we're going to whack you. So that was pretty good. I didn't miss your super chat. I read it. You misread your super chat? I'll read it again. We need to compare wet ass pussy to get him to grab him by the pussy. We did a comparison. It was Jim Griffin. Yeah. There was that woman today with the car killing mama verdict. That was pretty exciting. So this woman and her beau locked the woman's daughter, who was mentally and physically handicapped, in a car in South Carolina for 5 hours, and she died, unsurprisingly, of the dehydration and heat stroke, as one does. And there was a question in my mind as to whether or not she could be convicted of murder, because it wasn't clear to my mind that it had the malice element of the malice murder that was being charged in South Carolina. So murder, of course, as you can appreciate, is defined different ways in different states, and sometimes in different kinds of flavors of murder. So this particular murder was malice murder, which requires the hatred, the hatred and the intent to kill, which to my mind wasn't immediately evident based on it, right? This looked like reckless and conscious disregard. It looked like she didn't care. Like she put the child in the car. She didn't put it looked to me like she put the child in the car not with the intent or design to kill the child, but rather out of reckless disregard. And I didn't think that met the definition of malice as I understood the jury instructions, although there was some dispute in the chat about how we were reading the jury instructions, which goes a long way as to reading the jury instructions. But anyways, I thought it was a little bit dubious. And then the woman had a whole bunch of people read these statements on her behalf about how she was a good woman, and I ceased to care. She had a whole bunch of people come forward and be like, you shouldn't punish her. She's been punished enough. She's been tortured already. And I'm like, really? Really? You want to use the word torture? Seriously? You want to say that this woman has been tortured? And then her daughter at one point gave up and said, oh, my mom has even gone so far as to lock herself in the car at the cemetery so that she could feel what her daughter felt. And the judge asked this great question. Yeah, how long did she lock herself in the car for? And the daughter's like, I didn't even bother to ask. It was such a great thing. And so, yeah, they gave the man 32 years and they gave the woman 37. It was a minimum of 30. And so the judge thought that the woman was a bit more responsible on balance, which, fair. So, fair. Malice inferred by excessive disregard for human life. That can be inferred. But you see, the way I read that, right? I read it as a permissible inference, not as a mandatory inference, right? I read it as if a person has extreme disregard, you can use that as an inference that they contain the underlying malice. But I read that as a permissible inference, not as a mandatory inference. So if you like, it's evidence of malice, not conclusory. Right? So I'm like, okay, there's reckless disregard. There's a whole lot of disregard. I could use that as a basis to conclude that she actually had malice, but I don't reach that conclusion. So that's where I sort of got into a trouble with the jury instructions, right? It was, in my view, a permissible inference, and I didn't reach the inference. So that was me. Thank you, Angie Torres, for the 10 gift memberships. And she got married again, yeah. What's going on with Kohberger? Not much that I'm aware of. There's a whole fight over whether or not press will be allowed in the courtroom, and I don't really have much to have that. Sandy asks, please explain about the conspiracy charge. Yeah, so there's a difference between the conspiracy and the act, right? Conspiracy requires agreement between the parties and an act in furtherance of the agreement. So conspiracy is you and I agree. But you can have the action without the agreement. Like they both performed actions sufficient for the murder without agreement. So there was no agreement. There was no concert. They just both performed actions in it, like as an accessory, right? So it's the difference between being like an accessory and a conspirer, right? Being an accessory to the crime is different than a conspiracy. Conspiracy is like we agree in advance and then commit the crime. There was no evidence of conspiracy. The state didn't even put on really evidence of conspiracy. They only put on the tape of the 5 hours, which was recorded from a tape on the property of the defendants themselves, which is kind of hilarious because using their own evidence against them. And they basically said, well, see, they're hanging around and they're talking. That's res ipsa loquitur. It shows the conspiracy. I'm like, no. So they didn't find the conspiracy, which I thought was perfectly fine. Yeah. Let me see if I can find the actual judge's instructions on malice murder. Hold on. And we can discuss it. Let me see if I can find the jury instruction. Let's see. This is going to be a problem, isn't it? I hate when I try to look up. I hate it when I try to look up things on the fly and then I can't find it right away because then I get stuck as I try to figure out what's going on. South Carolina Judicial Branch, probably. Suggested jury instructions in civil cases and criminal available on website. Well, that's what I want. The suggested jury instruction documents were removed from the Supreme Court's website at the request of the Supreme Court. Oh, that's great. So now I have to find the jury instructions and I can't find them on the fly and I look incompetent. I can't find them, so we can't discuss them. All right, let's move on. Are they on Pacer? No, Pacer is federal. This is state. Passenger mom arrest. I haven't heard anything about that case. So, sorry, I don't know anything about that case. There's always too many cases going on. It's too hard to know about all the cases going on. There's cases going on all the time. I do nothing but read cases, and still a lot of it passed my attention. Am I expected to hear any decisions from the Supreme Court of interest this month? No. I'm quite positive that we will hear no decisions from the Supreme Court this month. The Supreme Court's not in session. What about the main topic from the thumbnail? We already discussed that. We discussed it at the start of the stream. We discussed the Burger King lawsuit recently in a stream where Burger King's being sued for not putting enough meat. Where's the beef on their burgers? Was Danny Masterson federal? No, that was state of California. What was my favorite case you covered in my morning roundups this week? Oh, I don't know. What I really wanted to do recently, what we could do is we could do the briefs for the Mark Meadows case, federal. I really want a copy of the transcript. I asked the lawyers in the case for copies of the transcript, but they haven't responded to me, presumably because their email boxes are crushed full and they never saw it. But we could cover the briefs in the Mark Meadows case as he tries to remove his case to federal court, and we could try to discuss whether or not there's a cause of action there. Rob's button looks slick. It does look slick in the background, doesn't it? Can I go on with going with Tom Girardi mental capacity hearing? I have no knowledge about that. Never heard of it. I have no knowledge of that, so I can't comment about that. Any thoughts on Buster and snippets of his interview? No particular thoughts. Do Meadows? It's kind of a deep dive legal discussion, but okay. Let's see. So I got the original motion. I got the notice of removal. And there's a supplemental briefing. We could review. '66, '67, 1, 27. Okay. How many people are watching right now? $270? That's pretty good. Okay. All right. All right. Okay. Let's see. Split it. Okay. Great. All right. All right. All right. So let's tee up this issue because we're going to be here for a hot minute talking about this in some depth. All right. So we're going to be here for a hot minute talking about this in depth if this is what you guys really want to do. Because we need to read 14, 36, 53, 72 pages of documents. And I'm happy to do it, but I just want you to know we're going to be here for a while because going through 72 pages is going to take a minute. So are we really wanting to do something that deep and that thoughtful? Because this is going to take some real effort. So I just want to make sure that's something you guys really want to do before we do this. I can give you a quick foundation for it, sure. All right, so as you are certainly well aware, Donald Trump is being prosecuted by various authorities for various crimes. Of particular note for our case today is the state of Georgia is prosecuting Donald Trump for his phone call to the Georgia Secretary of State asking for them to magically find like 11,000 votes, whatever the number was. They have charged Donald Trump, Mark Meadows, and a whole bunch of other people with a whole bunch of crimes under Georgia's version of RICO. So this is a state-level prosecution. All right. Mark Meadows has filed a notice in federal court asking this case to be taken from the state level to the federal level, which isn't something you can normally do as it relates to a state prosecution, but you can if it relates to your role as a federal job. Okay? So there's this federal, you can't normally magically change a state case into a federal. That's not a thing. Right? The state of Georgia gets to prosecute you normally. You can't just magically turn it into a federal case. But you can if it relates to your official job function. Right? The reason for the rule in principle is that we don't want the states individually to have any power to criminalize a federal job function, because that would be a way for them to nullify federal law, which we don't allow, right? The idea that states can nullify federal law, not so much. We had that war already. So, states cannot nullify federal law, right? They don't have to necessarily help the federal government, but they can't interfere with the federal government either. They can't prevent the federal government from functioning. So what we're trying to do, at least in principle, is prevent the state of Georgia, or any other state for that matter, from attempting to constrain any member of the federal government in the course of their official job function by making it a violation of state law, which, wouldn't make any sense, right? It's like, okay, let's suppose the FBI wants to arrest people for violations of, I don't know, some federal crime, and some state doesn't want to let them do it, right? So it's like, okay, we'll make it illegal. Some states we'll make it illegal for the FBI agent to enforce the law within the bounds of our state. And we'll make it illegal to the point where we'll make it a violation of our criminal law, and we will arrest the FBI agent and charge them with a violation of our state law. If this sounds pretty stupid, it's pretty stupid, because this doesn't make any sense, right? Why would we let you do that? Why would we let some state somewhere create a criminal offense that would allow them to prevent the federal government from acting? The states can't make illegal what the federal government makes legal, okay? So Mark Meadows is saying that what he did, that he's being accused of, was part and parcel of his role as chief of staff for Donald Trump. He did those things as part of his official job function. And so, therefore, this should be heard by a federal court, which would then be in a position, presumably, to dismiss the charges. Because the case then being taken to federal court, if they were federal defenses, the federal court would be like federal immunity and dismiss the case. So it's a way for the federal government to dismiss a state-level case. So Mark Meadows has asked for this, and what's interesting, of course, about it in principle is that we expect Donald Trump to also do this move. Donald Trump has done this already with respect to the New York case from Bragg. It didn't work for Bragg because Bragg was going after Trump as it relates to his business dealings, which did not relate to his role as president. So among the many defenses, it relates to my job function, though, not so much. Because what Bragg was prosecuting for was business violations. They had nothing to do with Trump being president. They, at least in principle, they had nothing to do with Trump being president. So Trump already tried this with the Bragg indictment. And so although he hasn't tried it yet with respect to the Georgia indictment, we expect that he will. And obviously, this has a lot more to do with him as his job as president, because a lot of the acts occurred while he was president. And so if it gets to federal court, that means two things. First of all, it means, at least theoretically, the charges could be dismissed because, you know, if it's within the job function of the president, then it's within the job function of the president. There's absolute immunity, and the case just goes away. So possibility number one is the case just disappears because it's within a federal protected role, and the state can't make illegal what the federal government makes legal. So that's possibility number one. Possibility number two, which is much more likely, is that the case doesn't go away completely because at least some of the state offenses or some of the state charges might remain, but the jury pools are different, right? Because federal courts have a different jurisdiction than their state law equivalents. So the state court would be pulling from Fulton County, which is to say Atlanta. Right? If this goes to federal court, it would be pulling from the entire Northern District of Georgia, which is half the goddamn state. So it is more likely to be a much more favorable jury pool because, you know, Atlanta is more likely to lean heavily Democratic than, for example, the entire northern half of Georgia. So he is more likely to get a more favorable jury pool and therefore a more favorable jury, even if the case is heard in federal court, because they're different jury pools. Also, as a sort of bummer for us on sort of LawTube, if Trump is, of course, successful in taking his case federal, that means no TV. Because the state just said today, yeah, this whole thing will be broadcast. Every part of it will be broadcast and televised and live streamed, which is great for us as LawTube. But of course, if it goes federal, not so much because they don't allow cameras in the courtroom and feds. So there's that. So this whole thing that we would be discussing today is deep diving into the arguments as to whether this can or cannot be taken to federal court. That's what we would be doing and reading all that stuff. Patty Thomas says it's within the presidential power to find 12,000 votes. Well, it depends how you parse a lot of that stuff, Patty. And also depends what part of it you're looking at. And that's also part of the issue that's in dispute about the whole thing. It's like, does Trump need to be able to attack the entire cause of action? Or does he need to only does he only need to be able to successfully attack particular actions? Because Georgia laid out a whole bunch of what they called overt acts. Like Trump made this phone call. Trump sent this email. Trump did this thing. Trump did this thing. Trump did this thing. So does he need to be able to nullify all of it? Or does he only need to be able to attack some of the acts? And also, by the way, for the standard in federal court, it's whether or not he has a colorable defense. So he doesn't even need to prove at this point that he's right. He just needs to prove there's a chance he's right. Right? So in the end, the court might ultimately say that you have no defense. The question at this point is whether he has a colorable defense, whether it is non-frivolous. Does he have a non-frivolous argument to argue that some or all of what he was doing was within his official job function? So, or not, by the way, because that was also part of the supplemental briefing, because the court asked the question. The court asked the question, like, wait a second, do I need to find that Trump has a viable defense to, like, an entire cause of action? For example, the RICO? Or do I only need to find, or Meadows in this case, but same difference. So, like, do I need to find that Meadows has a defense to the entire cause of action? Or do I only need to find that he has defenses as to some of the overt acts? Which, you know, yeah. Because if he has defenses as to some of the overt acts, if you assume the premise that he has colorable defenses as to some of the overt acts, and those are successful, then some of those overt acts would disappear, which necessarily one would presume makes the cause of action weaker. Georgia presumably put all those overt acts in there because they thought that they made their case stronger. So, you know, if you attack and you can get rid of some of those pillars upholding the cause of action, even if it doesn't cause the entire cause of action to collapse, it makes the cause of action weaker, which is obviously beneficial, right? Because it's like, how much evidence do you need, right? If you can take away some of the evidence against you and weaken the prosecution's case, you know, there is a pretty far difference from technical sufficiency to bring a charge and ability to get a jury to convict. It's like technical sufficiency is pretty low, but what you actually need to win, it's like, yeah, so if you can attack enough things, then you win. Even if there's technical sufficiency, you win. And so that's good. Colorable defense is what, 51%? No. I interpret it to mean non-frivolous. I interpret it to mean more like 10% is how I would interpret colorable. Colorable means plausible, realistic, non-frivolous. 10%. 10% chance. It's pretty low. It's pretty low. Colorable is, we're not going to throw you out of court and laugh in your face. 10%. Is too much for this time of night? Okay, we can do something else. So, we can do something else if it's too much for this time of night. What else do you guys want to talk about? I'm here to entertain you. What do you guys want to talk about? Any news on Without a Crystal Ball? Without a Crystal Ball still chugging along. Last I saw, they were stuck in discovery motions about what is or is not going to be provided by Discovery, and that gets too technical for my knowledge base. It gets too it gets too technical. You know, like, I have a pretty wide knowledge base, but, you know, like, I don't have the depth of, like, a true subject matter expert in some things. So, like, you know, I can go pretty high in sort of depth, but, you know, when you get deep enough in a subject area, I'm like, yeah, I'm out of my depth because I'm not a subject matter expert. And discovery issues, particularly in a different state, under different state, it's too deep for me, right? My knowledge base is wide, but I'm not like an expert on everything. I can't be an expert on everything. And so it's like, okay, we're in the finer points of discovery issues under state-specific law. And this is the part where I go, I'm out, and I'll let you know how it turns out on the backside, and then we'll get back into it, you know? Why is it too late? Someone said it was too late in chat, and someone said it was too late for this time of night. Someone thought it was too heavy and too late for this time of night. So I try to be responsive to the chat best as I can. So I thought maybe that was a responsive thing. Maybe people thought it was too late or too long. You know, on the back side of it, where the judge, you know, provides all their rationale, I'll be able to understand it. I'll be able to critique it. But I don't know enough to be able to generate it in the first place. Like, I can't give you an answer in the first instance. I can't generate it. I can understand the answer. I can critique the answer, but I can't generate the answer. You know, it's the difference maybe between being able to write a foreign language and read it. You know, it's like, I can't write this. I can read it. I can understand it. I can critique it, but I can't write it. So it's outside my knowledge base. And by streaming on Monday, I was thinking about it. When do senators and other politicians have to retire in the U.S.? They don't. They don't. They can run forever. When will I do another video on Great Scottish cases? As we have time. We could go troll the National Archive and try to find a case we want to do from the past. I don't feel like I'm doing a very good job entertaining you right now. I wish I had something more to respond to. I wish I had something fun to just watch and play. Let me take another look at the story suggestions and see if there's something fun I can just use. What about alternating between good and bad cop videos? I mean, I don't know what they are in advance before I watch them. So I mean, I don't know what they're good or bad without watching them. This may be too controversial, but did the case on gender affirming care being ruled on now? In which states? I've covered that case in so far Kentucky, Florida, Texas, and I think Alabama, and also somewhere else, I think. I think I've done that case 5 different states. So which case on gender affirming care? There's a couple of them. Have I covered Sidney Watson versus Blaze lawsuit? No, I don't think I saw that when it was filed. Where have I traveled? When I was 15, I did missions work for a month in Port-au-Prince, Haiti. I spent a month in a tent on the grounds of an orphanage in Port-au-Prince, Haiti, wherein I hand-mixed cement and laid cinder blocks and constructed a church for people who had their church taken down by one of many, many, many floods in Haiti. It was a very interesting experience. Being in Port-au-Prince. What was notable to me was what was interesting to me was I didn't notice the poverty when I got there as much as I did when I got back, which I thought was just kind of interesting and sort of like how I reacted to the thing. It was just interesting, like how my perceptions of wealth or the difference of it clicked in my mind or didn't click in my mind. Like, it didn't really bother me very much when I got to Port-au-Prince, Haiti, and the conveyor belts in their international airport were made with wooden planks. And, you know, there were no x-rays, and it was all hand inspected because that's what they can afford because they're the poorest country in the entire hemisphere, right? So the fact that their baggage carousels were made of wood and the bag inspections were done by hand, the streets were made of dirt. When it rained, to any real degree, it would cause massive flooding that would cause the buildings, which were often constructed from whatever happened to be laying around on the ground, to just completely wash away. So you'd get like one of those, you know, heavy Miami rainstorms, which in Miami, you know, not that big a deal, but in Port-au-Prince, Haiti, the streets would completely flood. All the homes, well, not all the homes, but a lot of them were made literally from whatever scrap we happened to find laying around on the sides of the street, and, you know, bound together with, you know, yarn and duct tape and whatever else. And so the homes, of course, are on absolutely no foundation of any kind, and so the homes would just completely be swept away into the streets. There are no gutters, so, you know, all the sewage would completely raise, and there'd be sewage just all over in the streets, and it would smell very badly. It was very interesting because there were banks everywhere, but the banks weren't banks. They were just illegal lotteries, but they were everywhere. You could just go into one of these banks and gamble, and they were all over the place. At the time, Port-au-Prince was trying to like convert to a new currency, but like the money for it didn't actually exist. So all the prices were in one currency, but the money we had was like still in a different currency, which was really inconvenient because you had to do the conversions twice in your head, because you had to convert from the price on the shelf to the money that actually existed, and then you had to convert again into the US dollar to figure out what the hell you were spending. Right? So that was really weird. That it's like you're spending money on a currency that doesn't exist, or at least we didn't have it. So we had like the old currency that was there. It was interesting. You like would go to these farmer markets, and people would just be around these markets, and people would just, you know, come around and chase you down to sell you like one of these like freezer pops that you would get, you know, during the summer. And they sell it to you for a mark, which I believe at the time was something around a 1/15 of a dollar, although I'd have to double check my conversions. And they'd sell you this thing for like, you know, basically the equivalent of, you know, whatever. You know, you'd buy like an entire like thing of soda for like, you know, $1 or whatever. You'd buy like a 2-liter of soda, and you feel guilty for drinking it because, you know, you've just basically flashed more cash than like the average person on the street has in their lifetime. You feel really, really guilty because you're just a kid, you know, you're just a kid there, you know, and you're not particularly wealthy by US standards, but it's the poorest country in the hemisphere. So basically your economic spending power is greater than like everybody. And so it's like really weird because you have more economic spending power than like the entire culture. And it's a very weird experience to be in. You go around in these vehicles. It would take you forever to get anywhere because the roads aren't paved. There are no street signs. There are no traffic lights. So it would take you forever to go anywhere because, you know, the roads are a complete nightmare mess. It was a very interesting experience. It was very warm. It was very hot. We took anti-malaria pills At least some of us did. We were supposed to. One of our number decided, that he was a big, strong boy and didn't need no anti-malaria pills. And he decided to drink water straight from the well without running it through a filter first, like, we were told to do. And so we got back to the States and he got malaria, and I think he got hepatitis C. So, didn't work out well for him, I guess. So, it was an interesting experience. This is 1996. So in 1996, the entire country is UN occupied. Because, it's in turmoil. So, you got the UN patrolling the streets. And this is where we're camped out for 34 days. I was in Port-au-Prince, Haiti for 34 days in the sweltering heat, outside, living in a tent, no air conditioning, in the middle of an orphanage, in the middle of Port-au-Prince, Haiti, working outside doing construction. Good times. So that was some interesting experiences. Then the following year, 1997, I did a missions trip in New Frankenrode, Germany, which is a very, very small town near Gotha in Germany, in former East Germany. I think New Frankenrode has a population of something like, 2,000, and Gotha isn't much bigger. It's a very, very small town in former East Germany. So we were there doing missions work in New Frankenrode. And again, although we had much better accommodations, we had running water. That was nice. We actually had like someone who made us food. So that was nice, instead of like just eating out of cans all the time. That was pretty cool. Again, like we were working at this place where helping the missionaries with like their farming efforts, because these missionaries were using like their farming equipment to help get money to like, spread the word. And so we were helping with them. So we would go every day into the fields and pick cherries. I think we picked something like 4,000 pounds of cherries. We were renovating this barn by getting up on scaffolding, which we built ourselves. We're 16-year-olds. Okay, we're 16-year-olds on scaffolding that we constructed ourselves in Germany, scraping the paint off of the walls of a barn. It's amazing we didn't die. It's amazing we didn't die. Also, the barn itself, I think, was older than the United States, which was pretty cool. Just being in this barn. We went into another barn and we put down a floor, and all we had to do it was water levels. All we had was water levels. So you use water like in a tube to show you the level, right? You have water in a tube, and then you have water at one level and water at another level, right, in the two tubes, and they're at the same level because, gravity. And you use this to line up all your things and to lay down the floor. So we would drill these holes into the ground and put stakes in the ground, and then we'd have to level them all with the water level, because that was our technology level. And I think at the end we were off from like corner to corner by something like 5 centimeters or something, which was pretty fucking ridiculous. Like, it was this huge floor, and like from corner to corner we were only off by something like 5 centimeters using water. to level, water in a tube as your leveling mechanism. And that's pretty cool. We then built also a shower in the middle of a field in order for the Royal Rangers to have a gathering. The Royal Rangers are like a hyped up Christian Boy Scouts, and they wanted to have a meeting in the fields of this farm. I'm not sure how they chose New Frankenrode or this farm to have their meeting in, but they did. And something like 40,000 of them came to this field and like had a meeting. And the entire population of the town is something like 2,000. So like 20x the population of the town just shows up and camps in my field that we built, that we built a shower for so that people could like shower and stuff. So there was that. Oh, I remember this one time we went to this German Renaissance fair, and we were watching a play in German because it's Germany, and I remember the play very vaguely. What I remember from the play, and I don't even remember that there were words in it, so the fact that it's in German doesn't matter, because I don't remember there being words in the play. What I remembered from the play was, like, people were, like, in a tavern. It was like a tavern scene. Like, people were just, having fun in a tavern, doing tavern-related things. There was, like, dancing and, music and people dancing and, like, people were happy and stuff like that, like kind of like a festive tavern scene. And then like a guy in like a black armor would come in, the music would stop, everyone would freeze except for the Black Knight. He'd come in, all the action would stop. He'd come in, look menacing, and then he'd leave, and then everything would resume again like he wasn't there. And this went on for like 2 or 3 times. The people would be happy. They'd be, joyous and dancing. The Black Knight would come in. All the action would stop. They'd have the ominous music. He'd leave. And then I guess the plot of the play is around the 2nd or 3rd time, the town folk notice that this is happening because like time is freezing, so they don't notice it right away. And then they fight the knight, and I guess they win. I guess. I don't really remember. It was weird. Also, it was German, which okay. So there was that. So, I just vaguely remember those plot points. So if that sounds like any play you've ever heard of, you know more than me. So, I don't know what to tell you. That's all I remember. Let's see. I've been to London twice. I went once as the debrief. So when you did the missions, it was Teen Missions International out of Cocoa Beach, Florida. I don't know if they're still there, but you would do like 2 weeks prep in Florida before you would go. And then you do like 8 weeks or something, or 34 days or whatever it is. So you do 6 weeks or whatever it is in mission. And then you do a week debrief. And this was the plan. And so when I did Haiti, the debrief was in Florida, which kind of sucked. Oh, that reminded me. I kind of forgot that plot point from my discussion of Haiti about how I didn't really notice the difference in wealth until I came back. I forgot that plot point. Because as I mentioned, like when I went to Haiti, I saw the baggage carousels with the wooden planks and like the hand inspections of the stuff, and the roads that are paved that aren't paved, they're just dirt, and the housing that just floods and everything. And I didn't really notice it until I got back to Miami International Airport. And I'm not sure why, but it didn't really click until I got back to Miami International Airport. Because when you fly into Miami International Airport, you know, there's air conditioning. It's inside. It's well lit. There's neon lights. The baggage carousels are made of, you know, polymers. The runways are paved. Right? There's like Burger Kings and other food concession stands that are there. And so basically you have literally gone from basically you've arguably gone from the poorest spot in the entire hemisphere, right? You've gone from Port-au-Prince International Airport, which is arguably the poorest place in the hemisphere, and you've flown into Miami International Airport, which is arguably like the richest place in the hemisphere. So, you know, I kind of noticed when I got back. It made me really happy to be an American. I literally kissed the ground because I was like, you know, damn. It made me feel very, very grateful very, very quickly, you know, that I could, you know, buy a burger and a soft drink and use a toilet that flushed. And there were water fountains that had water in them. And there was interior with lighting and air conditioning. It was actually kind of cold because, you know, of what I was used to. So it made me very, very grateful to be an American. So I kind of missed that part of the story when I was flying back. And I couldn't tell you why I didn't notice when I flew to Port-au-Prince, but I definitely noticed it when I came back. Anyways, back to you know, I've often commented that it's basically impossible to be that poor in the United States. That's one thing that I saw that like made me really think about like how glad I am to be American. Like it is just not possible to be as poor as the poor people are in Port-au-Prince. It is not possible to be that poor. It's like you can literally be homeless on a tent on the streets and you're better off because you have streets with pavement and like you have bridges that can block, you know, the rain and shit. And I'm like, it makes you really, really glad to be an American because it's like you literally cannot be as poor as a poor person in Port-au-Prince. And it's like, it's pretty kind of sobering experience. You know, it's a sobering experience. Anyways, yeah, and then Laura reminds me, and maybe we'll get to this story later. Laura reminds me that at some later point I went to law school and I had a murderer for a roommate. But we can get to that story later. We're back in 1997 talking about London after my trip to New Frankenrode, Germany, near Gotha, in the state of Thurgen, I think it's called. Thurgen, maybe. Is that a German state? Am I close? Anyways. So yeah, so I went to London in 97, and then I went back again. And then I have a good story actually for this. I have a good story for this too. This is 2000, or is this 99? Let me think. This is 2000. My then high school girlfriend is going to go on a trip to France because she's in honors French. And so I'm a freshman in college at this point. She's a senior in high school. And so I tag along with the group. And on our way to France, we went to London. And I actually have a pretty interesting experience about that. When I was in London, we were with the group, and the group wanted to go see like a play. They were trying to like do like off Broadway. I don't know what the right nomenclature is, but you get the idea. They were trying to find tickets for like London theater, and we were walking around like looking for tickets. I didn't want to go see the theater. I wanted to go to Greenwich and see the atomic clock because I'm geeky and shit. But no one wanted to go with me. So they're like, you can't go by yourself, even though at this point, of course, I'm a legal adult because I'm 18 or 19 or something. But they're like, you can't go by yourself. You need a chaperone. I'm like, okay, whatever. So anyways, I was with the group, and we were walking around, and we went into some sandwich place for lunch, and I don't know exactly what happened, but apparently the group collectively decided that there were too many people there. It was somewhat crowded. There were too many people there, and the group decided to leave, and I didn't notice, which I guess kind of makes sense because it was a crowded restaurant, right? So our group came in, and, they apparently collectively decided there were too many people, and they all left, and I was left behind, and I didn't notice. And fortunately for me, I had a business card of the hotel we were staying at, because my father had told me, it's like, when you're traveling, just put the business card of the hotel you're staying at in your wallet. You never know when it will come in handy. Good pro tip from Dad, because otherwise I'd be really fucked, because I don't know where the fuck I am, right? I don't know what the hell's going on, and I don't have memory for shit. I don't remember the name of the hotel, but fortunately, I have the business card of the hotel we're staying at in my wallet. So, good pro tip from Dad. So, I left the place looking my friends, and I couldn't find them. And so I was like, well, I need to go back to the hotel. Now, at this point, I have never used a taxi before. I've never used a taxi before, so I don't know how to use a taxi. It's like, because, I've never used one before. And it's like, I don't know what to do to how to use a taxi. I'm like, what am I supposed to do? I don't know, because I've never done it before, right? So I was like, okay, so I'll just walk it. So, somewhere from one of the, vendors or something, I find a street map of London. I pick up a street map of London, and I just look at the map, and I'm like, okay, well, there's the name of the street of the place. This is where I am. And so I need to walk from here to there. And it was quite a hefty walk. It was a healthy walk. It was like, I forget what it was. It was some distance. I don't want to overly exaggerate it, but it was probably like 2 or 3 miles. It was a notable amount of distance. But I was like, that's okay. I can just walk back there and, do that. And so I'm walking back to the hotel, and of course I haven't eaten yet, because we went into the sandwich place to try to eat, but as I mentioned, like, everyone left, and so I left to try to find them, and I couldn't find them, so I haven't eaten, and so I'm getting kind of hungry. So I am walking through Piccadilly Circus. There's a roundabout at Piccadilly Circus, and I'm walking through Piccadilly Circus on my way back, and I'm hungry, so I basically just kind of pick. It's kind of like, it reminds me of like LaFont Plaza in DC, sort of, sort of big roundabout with like kind of 7 kind of streets coming off of it, that you can kind of walk in any direction. There's a sort of a large roundabout, and, there's shops, and you can kind of walk in any direction, and there's got like 7 different streets kind of interacting or whatever. Or like DuPont Circle, something like that in DC. Anyways, so I sort of pick some arbitrary direction, and I just look for any place to eat. And there's this very little hole-in-the-wall shop, very small hole-in-the-wall shop that's selling sandwiches. And so I buy a ham sandwich and a Coca-Cola, and they give me my bag with my ham sandwich and they give me a 12-ounce Coca-Cola, and I pay for whatever it is, and I walk back like the 2 blocks back to Piccadilly Circus so I can sit down and eat. And I open the bag, and it's literally ham on bread. You know, there's no cheese, there's no lettuce, there's no tomato. It's literally ham and cheese, or maybe there might have been cheese, but it's like ham, cheese, bread, and nothing else. I think it did have a little packet of mayo, but I'm like, this is some bullshit. You know, there's no like dressing on it, right? It's just ham on bread. So anyways, I take out my little mayonnaise packet or whatever it is, and put it on the sandwich, and I sit there with my warm Coca-Cola, and I'm drinking my warm Coca-Cola in the middle of Piccadilly Circus, just watching the traffic go by, and it's a pretty good memory. Just eating my sandwich, my ham and bread, just sitting there and watching the traffic go by, and that's the kind of thing that will stay with you. So, yeah. So it was pretty interesting. I did make it back to the hotel and all the rest of it, yeah. My girlfriend and I were not on the best terms at this point. By the way, in case someone in chat noticed, like, your girlfriend didn't know I was with you. Yeah, my girlfriend and I weren't on great terms at this point. So, she didn't notice, and I'm not sure she cared. So, yeah. So that was pretty interesting. So there's some good stories. And other places I've been before, let's see. I've been to France, of course, as I mentioned, because I was with her on that trip to Paris. So I went to Paris with her, and I climbed the Eiffel Tower. I climbed the steps of the Eiffel Tower. That was pretty cool. Saw Napoleon's tomb. That's pretty cool. Recommended. Very nice. I've been to Germany, been to Jamaica, Mexico. Yeah. So that's pretty good stuff. Oh, you guys don't want to hear the murder roommate story. You don't want to hear the murder roommate story. All right, I'll tell you the murder roommate story. All right. So, it is 2004. I am graduating undergrad, and I'm going to go to law school. Now, I'm graduating undergrad twice because I got 2 degrees. I graduated in May of 2004 with a computer science degree, and then I graduated August of 2004 with a political science degree. I mention this because law school also starts August 2004. So I have something like a week and a half between the end of undergrad and the start of law school. I'm going to law school in Ohio, at Akron, Ohio, was where I went to law school. And I graduated from Clemson. And so I can't really go to Ohio to look for apartments and stuff because, I'm kind of busy doing classes at Clemson, finishing out my degree. So I rent blind. I rent an apartment blind. I forget exactly how I did it. Contacted the law school, whatever. They hooked me up with someone who hooked me up with someone. I sign a lease blind. No idea what it is. Okay. It's I have a lease for an apartment I've never seen. All right. So anyways, I get my stuff and drive up to Ohio. And I get there, and this house is a tenement housing. It is an absolute derelict piece of absolute shit. It is walkable on the wrong end of campus. And I did walk to class. I walked to and from class, I think, every single day. And it is a long walk because it is right across the entire length of campus. I'm on the far end of campus. I'm in this house which sits on an on-ramp to a state highway. The house has a basement. It has a first floor that has a kitchen. It has a second floor, and it has a third floor. The house is an absolute piece of shit. The entire house can't cost more than, like $30,000 or something. It is a 4-story fire hazard wreck that I'm surprised didn't kill me. All right, it is beat and battered to death. It is a complete shithole. I get there with my father, and we start to move in my stuff. And man, my father would comment after the fact how glad he was my mom wasn't there, because my mom would have lost her shit. Like, not my baby, right? Not my baby. It's like, yeah, your baby. So I have this complete death hole apartment in Akron, Ohio, in the wrong part of town, on the other side of the highway. Okay. In the apartment was a basement, which was a complete nightmare. It was dusty and dirty and full of shit and completely unkept, and there were rats and all the rest of it. On the first floor was a non-law student, the only non-law student in our building. I forget what his name is. He's the murderer. I probably should remember his name, but I don't, but we'll get there. So we have the non-law student. Then we have me and my friend Phil. And I think on the upper floor is my law friend Jeff. So it's three 1Ls. 3 1Ls. And I think on the top floor was a 3L. Right? So this is what we got. We got the non-law student. We got 3 1Ls and a 3L. 3 first-year law students and a third-year law student. All right? And, we're living in this apartment, and I'm going to and from class every day, and, parking on the streets, and people were leaving me notes about not parking on the street, and I thought I'm going to die. And, yeah. So, fast forward, I think it's January or February. I think it might be the next semester. I don't remember exactly when this happened. But I get a knock on my door one day. I have a second floor apartment in this house. Get a knock on my door, loud knock on my door, Akron police, open up. I'm like, okay, wait a minute. I throw on some jeans and a shirt and open the door, and sure enough, it's the Akron police outside my apartment. And it's like, we just have we're here to investigate. We're here investigating, and we're conducting a search warrant. And we're searching in the basement. And we just have a couple questions, if you don't mind. And I'm like, okay. So the police ask me, so this is on a Wednesday. And they ask me, where were you on Monday? And I'm like, right? I was like, And they're like, okay, let's try this. Where were you yesterday? And I'm like, because you know how it is, right? You know how it is. You're doing the same thing every day. So none of it's particularly memorable, right? I go to class. I go to the law school. I stay in the library sometimes. I write. I come home. I study. Every day is exactly the same. So nothing's particularly memorable. So what did I do yesterday? I don't know. Probably the same thing I do every day, but not enough for me to detail my movements in any way. So, like, I say, like, where were you about this time and this time? I'm like, I think I was home. I think I was home at that time. Like, on Monday, I think I was watching TV in the main room. It's like, did you see anyone? It's like, not that I really remember, whatever, you know. It's like, you know, whatever. It's like, so it didn't really go well. It didn't really go well. It's just like, I don't really know, you know, what's going on. I don't really have a good memory of what's going on. I don't remember seeing anyone in particular. I'm not really sure I can help you. I'm basically the worst eyewitness ever. And I'm not trying to be unduly difficult. I just honestly can't remember anything because, like, my brain is completely shot. So, anyways, what happened, it turns out, you know, I talked to the police. What kind of law student was I? A first-year law student. You know, so here's what happened apparently, as I understand it later. My roommate, the non-law student, he is a part-time Coast Guard reservist, I think, and I don't know what else he does, but he's a Coast Guard reservist, and I forget what else he does, but you know, he's not particularly successful. And apparently what he did is he asked the 3L, who lives in the upper, he lives in the upper apartment. He asked the 3L a question. He's like, hey, my father has money in a trust for me. How can I get access to the money? Right? So he asked my 3L law student, like, my father has money in a trust for me. He won't give me the money. How can I get access to the money? And my 3L law student friend did exactly what I would do. He just worked the problem. He didn't even think about why he was being asked. He just worked the problem. Like, you know, like we all would. Like, we just worked the problem, right? So apparently they have a discussion about this. And apparently the answer was, well, one of two things has to happen. It's like either your father has to voluntarily change his mind or your father has to be dead. Yeah. So apparently, he went for option number 2, and he camped out with his own father in his father's backyard. Don't ask questions. I don't know anymore. I'm telling you, they had a camp out in his father's backyard. They got in a tent and they had a camp out in his father's backyard. And apparently, he bludgeoned his father to death with a hammer. So that was what the police were looking for in the basement. They were looking for the murder weapon, the hammer, in the crappy ass basement with the dust and the rats and all the rest of it. And they arrested him for check fraud on the day of. Because, as I mentioned, like, he had done this apparently in order to get the money. But apparently this wasn't his first thing that he did to try to get the money. Apparently one of the things he also tried to do to get the money was forging his father's signature on a check, to which his father apparently learned about this, which might have also somewhat incentivized the murder. So he forged the signature of his father, who apparently confronted him, which might have also led to the murder. So they arrested him for the check fraud, and I lost all interest in it, and I forgot what happened after that because I didn't care. So I lived with a murderer who murdered his own father in a little patricide for money. So that was my living with a murderer story. Yeah. Yeah. So that happened. Yeah. I just find it so funny. That, like, the 3L basically did exactly what I would do, right? He did exactly what I would do. He just worked the problem, and he gave what he thought was the correct answer, without even contemplating why he was being asked the question. You know, he just worked the problem. And I was like, that always struck me as funny. So that was a good time. And then there's the story of how I founded my own law review at law school, which is a pretty interesting story too. So Law Review is the academic publication for lawyers. So, you know, most professions have academic articles, like, and they publish in, like, you know, if you're a scientist, you publish in something like Nature, right, or something like that, right? So the academic publications for lawyers are called law reviews. What's interesting about law reviews is that most of them, not all of them, but a lot of them, are run by students. So it's an interesting academic. It's interesting how that's structured, right? Because the people publishing the articles are students, and so they're the ones that are doing, like, the review and of the articles and doing all the review of it, which is a really interesting way to go about it, right? So the peer review of the articles is being done by the students, which is a pretty interesting way of going about it. And, you know, because it's, you know, the students learn a lot because, you know, they're peer reviewing stuff that's being written by professors and approving it or disapproving it, right? So, and they're, you know, having to check everything. And it's a total pain in the ass. Okay? It's a total pain in the ass. When I did it, when I did law review, right, and you did a cite check, what you would literally do is you would literally pull every single source they cite and you would read them all to make sure that the citation was accurate and they weren't plagiarizing. So, like, you would, like, you'd basically redo their research, basically. It's a total pain in the ass. Like, you would pull every single source they cited and you would read it. And sometimes they would cite some really hard stuff to find and you'd pull it anyway, or you'd change the citation. If you couldn't find it, you'd just change the citation. You'd find something else that stands for the point and you'd change the citation. Because, like, you need to be able to prove it. And so, like, you would pull everything and you read it. It's a total pain in the ass. And then you get the blue book and do your citation check to make sure that they're written the correct way. Because if you do citations in law review, they're done by what's called the blue book. And it's a very fancy way of doing it, and it's a total pain in the ass. Anyways, so getting on law review is usually considered a pretty big deal. Barack Obama was perhaps somewhat famously the editor-in-chief of the Harvard Law Review, among his many other accolades. And being on law review is usually a pretty big deal. It's you know, shows you that, you know, it's usually a very good way to become, like, a research attorney or to become a clerk, because, like, you're pulling everything and you're citing everything. So it's like, it's good prep for a lot of different fields. So anyways, the University of Akron had at the time two different law reviews. It had the Akron Law Review and the Akron Tax Journal. And Akron, as a school, is home to the National Inventors Hall of Fame. It's right there in Akron. And they as a result of that, one of their specialties as a school is intellectual property, which was one of the reasons I went there. Right? So they have this intellectual property component because they're home to the National Inventors Hall of Fame. They do intellectual property. It's one of their specialties as a school. So Akron does not, at this point, have an intellectual property law review. Right? It has the main law review, and it has the tax journal, but it does not have a IP law review. So before I got there, so when I was a basically like -1L, some students wanted to start an environmental law journal, and that effort failed. But the law school said to them, if you want to start a IP law review, you can. Okay. So when was this? Was I a 2L or was I a 3L when this happened? It must be when I was a 2L. All right. So I'm a 2L at this point, and this idea has been sort of circulating around, right? Circulating around. And there's this guy who I believe was an LLM student. He was like a 4th L, basically. He was an LLM. He was master's. And he's like, okay, I'm going to be editor-in-chief of this IP law review. So it was going to be him, and he recruited a staff, right? He recruited a staff, and I was going to be one of the assistant writers. I was going to be one of the assistant editors in this law review. So, you know, there was like 7 of us or something, right? There's like 7 of us. And so I'm a 2L, and I'm basically like the junior man on the totem pole, right? At this point, I was a assistant editor of the Akron Law Review. So I'm working on the regular law review as a 2L, as a, you know, entry-level assistant editor. And it's like, okay, I'm going to kind of do the same thing in this new journal, the Akron Law Review. Now, the Akron Law Review, for whatever reason, did not want to have an intellectual property law review. So the people that ran, the students that ran the Akron Law Review didn't want to run an IP law review. I guess they thought that they couldn't handle it, or it was too much, or whatever. They didn't want to handle it. So they kept putting up resistance, right? They kept putting up resistance. They're like, we're not going to do this. We're not going to do this, right? They kept saying no, 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 no. And so, you know, this was happening at the end of my 2L year and into the summer between my 2L and 3L, right? We're trying to get this done. The law school administration wants law review to sign off on it. So they're like, you guys got to figure this out. You got to figure out how to play nice. And, you know, and they're just simply saying, no, we're not going to do it, basically. So, you know, we try to meet with them. We try and negotiate. I'm not really in on the negotiations because I'm a junior man, right? I'm not really in on these negotiations, but they're not working out. All right, so I'm just kind of hearing through the grapevine. And so little by little, the team that this guy had put together starts dropping out, right? Because it's like, it's not going to happen. And they have to start investing into other things, right? They have to start looking into, you know, moot court or mock trial, or they're going to do the clinic where they're going to take on cases, or they're going to do a part-time job, you know, working at a law firm, or they're going to, you know, do whatever, right? So people are like, you know, I can't keep committing to this because it's not happening. And I have these other opportunities, and these other opportunities are closing, you know, because these are all competitive opportunities. And so these other opportunities are closing. So I'm going to bail on this Akron Intellectual Property Law Review thing because it's not happening. And instead, I'm going to go do my clerkship or my, you know, whatever, right? I'm going to do that. So long story short, I'm literally the last man standing. Long story short, I'm literally the last man standing. And I refuse to give it up. And, you know, so I'm like, okay, I'll do it. So I go to law review, and I'm like, I want to do this. And they're like, no, you know, we're not going to do this. You know, we already have an editor-in-chief for the law review this year. We already have an executive editor for the law review this year. You're basically asking us to elevate you, you know, in our in our internal organization. You're basically asking us to elevate you, and you're not one of the people we selected. You're not one of the specials. And I'm like, okay, fine. So I ask for a meeting. I ask for a meeting, and I get the dean of the law school, like the dean of academics, the advisor for the IP program, right? The editor-in-chief of the law review, and me in a room. All right? And so I'm basically like, okay. So we're in a room, and I'm like, all right, I can do this. I can do this. Just let me know what we need to do, right? What we need to do. And the editor of the law review says exactly what I think they're going to say. It's like, we can't do this. We don't have a structure for this. We already have our people. We already have our editors. We already have our law review that we need to publish. We already have the tax journal we need to publish. We already know what we need to do to get that done. We don't have the staff. We don't have the staff to do this. Kurt can't do it. He can't come on and just do it. He can't use our people. We can't elevate him. He didn't apply for, a position and get elected, through the thing. We can't do it. And so I simply say to the dean, I said, look, Dean, if you want this to happen, I can make this happen. I can do it. You just need to tell me that I can. And the dean looked right at the law review person. They looked right at law review, and they're like, Kurt is now the editor-in-chief of the Akron Intellectual Property Law Review. So, go forth. Congratulations. And I'm like, kick ass. And so now I actually have to make this happen. Right? I have to actually put together this thing. And give me 1 second. Akron Intellectual Property Journal. Volume 1, Number 1, 2007, University of Akron School of Law. I did it. I did it. I recruited the staff. I got it done. And we published 2 volumes that year, which was our goal. We did it. So, a very, very cool accomplishment. And I believe they're still doing it, to the best of my knowledge. I believe 2 years later, the Law Review wound up annexing the IP journal. But you know, it's interesting because I picked everything. I picked the color. I'm not sure why I should be particularly fond of this, but the color of the journal is this color because I wanted it to be this color. Exactly. Right? Because the regular law, because one of them is blue and one of them's blue and one of them's white. I forget which is which at Akron. One was blue and one of them's white. And so I was like, you know what I did? I literally got out Pantone paint swatches. And I picked the one I liked the best. So it's exactly that color of red because I wanted it to be exactly that color of red. Because I was editor-in-chief. And it didn't exist before, so it got to be any fucking color I wanted. And I wanted it to be that color because I did. Yeah. So, yeah, I mean, I had to recruit that staff. I recruited that staff from anywhere. Maria Hill, who was my executive editor, was one of the original group that was in that larger group that we started with. So I was last man standing. And then when I got to be editor-in-chief, I went to Maria Hill and I was like, how would you like to be executive editor? And then the rest, I just like found people. And that was it. So it was a major accomplishment. It was a major accomplishment. It was a pain in the ass. It was a pain in the ass because at this point, by the way, we were like already like 3 or 4 weeks into the 3L year. So like the school year had already started at this point. When I went to the dean, I'm like, how about you just give me power and I can make this happen? And it was great too, because this is how I was like, I need something to give them. So this is how much the dean wanted the project, right? Hey, Dean, I know I'm a lonely assistant editor, but how about you let me run this? And how about this? How about you give me the power to give people a credit hour of legal school classes for the work? And I'll decide whether or not they pass or not. So how about you give me the power to give someone a credit hour towards their academic study, and I'll be the guy that decides whether or not they do it. And the dean's like, okay. And suddenly I'm giving out academic credit towards the law school as a 3L. And apparently giving credit to myself, I guess, because, well, I'm the editor-in-chief, so I guess I passed because I'm the one reviewing it. So, yay. So, I was able to get students on board because I was able to offer them academic credit towards their degree. As a 3L. I'm apparently handing out academic credit now. Okay. You know, it's nice when you have the dean on your side and the dean says yes. When the dean says yes, it goes a long way. So it helped a lot as I was able to recruit students because I was like, I can give you something. I can give you credit towards your degree. Yeah. So it was pretty great. It was pretty great. And, you know, at least as far as I'm concerned, we did a good job. We did a good job. We got it done. We got to, I think we published 9 articles. This one had 1, 2, 3, 4, 5. And I think volume 2 had 4. And we had a staff of 7 to do 9 articles. And God, it was so much work. So, yeah. No, I don't keep up with any of my staff members. I don't know where they are now. Maria Hill's probably off doing something pretty good. Maria Hills was a smart cookie. I really liked her. She's probably off doing something meaningful. So those are some of the stories from my life. And then I went and became a patent attorney for 15 years. And now I'm trying to figure out what the next step is. Look her up and see what's she doing. Like, I know, like, the managing editor for the regular law review, I think his partner now at some law firm. The editor-in-chief of the editor-in-chief of the regular law review, to the best of my knowledge, went to work for Jones Day for like a year, and then had a mental crisis and quit, and then raised chickens on a farm. So, yeah. And now I just need to figure out something else meaningful to do with my life, you know? I can do great things when I try. And now I just need to figure out what to do next and find someone who'll give me a chance to do something great. I need to figure out what's next. But this channel's pretty fun. This channel's pretty fun. And I did pretty well in school. I mean, law school was really intense at one point. I was insane. I was insane with how much work I was doing at one time. It's amazing that I didn't crack completely. At one time, I was simultaneously assistant editor for the law review. I was trying to get the new law review started. I was on the moot court team. I was on the mock trial team. And I was doing something like 15 credit hours at once. I was insane. And I graduated with something like a 3.4, 3.5 GPA. Yeah, I do well when I'm under pressure. I do well when I'm under pressure. I do well when I'm under the gun. It'll cause you to burn out, but I do better when I have more to do. How many people are currently watching the channel? Have I lost everybody? Or do we have time for more stories? I'm glad to hear that you're in law school, Jamie. If you need a professor, tell your law school about me. 229? What I really need, I think, is what I should really start looking for is a job as an assistant professor somewhere, I think. And I could teach a lot of different subjects. I'm pretty good at the law teaching. But I think I'd be a good professor somewhere. I just need to start throwing in resumes or something. Either that, or I need to apply to the Solicitor General's office, and maybe I can start, working on briefs or something, and maybe work my way towards the U.S. Supreme Court. That'd be cool. I think I'd like being a professor. I think I'm pretty good at it. I'm already teaching you guys. Got 2,500 videos teaching you guys. I need to do something more meaningful with the back half of my life, though. I need to do something that will be important and meaningful. So I need to become a judge or a professor or something. And although the plus side of I've got 229 of you, which is more than I'd have in any law school classroom by far. So, as far as impact goes, I'm not doing too bad. 229 people is a lot of people. That's your average law classroom is 20, 25, maybe 30. So I've got 10 times more people here than I'd have in any law school ever. So that's not too bad. I've commented before, basically, that I've effectively hired myself as a professor, because I kind of have, and you guys are my students. So yeah, it's I hired myself as a professor. I'm teaching. You guys are my students. You guys pay me. So I guess it worked out. I really like law. And I could teach most fields of law. I could teach any 1L subject. Contracts are not my strongest, but I could probably do it in a pinch. I got a D in contracts too, and I'm still pissed about it all these years later. I didn't deserve it. What do law professors do? They teach and they write. They teach and they write. They teach and they write about academic subjects they're interested in. And sometimes those academic articles go on to make something, you know? Yeah, I know. I'm still pissed about it all these years later too. I didn't feel like it was fair. I complained to the professor about it. He wasn't having it though. I did have one hell of an argument with my ethics professor, and I was totally right. And it took me forever to convince him I was right. I reviewed my final exam answer with him, and like I argued with him for like 40 minutes until he finally like bumped up my grade by like a step. So I bumped it up from like a C plus to a B minus or something. I was totally right too. I still remember it all these years later. It took me like 40 minutes to convince him I was right, and it's totally right. I can basically remember the ethics problem off the top of my head, right? So here's the ethics problem, okay? Here's the ethics problem in short, all right? You have a client who's come to you and asked you to do X. And you say to your client, okay, my rate is $500 an hour. I think, I need you to give me $10,000 up front towards that, and we'll bill as we go. All right, we'll bill as we go. So the hypothetical in this example says, okay, you have worked, it doesn't matter what numbers I give, but you have worked, let's say, 16 hours. You have worked 16 hours towards the objective, and your client comes to you and is like, I'm not happy with you. You're fired. And you're like, well, okay, I've done 16 hours towards this at $500 an hour. That's $8,000. Okay. And your client says, well, I think you suck as a lawyer. I'm not willing to pay you more than $3,000. Okay. So does that make sense? So you asked your client up front, you said to your client up front, my rate is $500 an hour. I need $10,000. We'll bill against that. You've worked 16 hours. Your client comes to you and he's like, I'm going to fire you. And you're like, okay, well, that's $8,000. And your client says, you suck. I'm not paying you more than $3,000. All right. So what are you supposed to do? Now, the correct answer to this question is you can't spend money that's not in dispute. You can't give yourself money that's not in dispute. But you have to give yourself money in dispute. So what the professor said is, well, you can't do anything with any of the money. The whole thing is in dispute. And so, you can't do anything with the money. The $10,000 just sits in the escrow account while you guys are figuring this out. And I'm like, well, that's wrong. That's the wrong answer. It is the wrong answer. Okay. The client, I think I'm owed $8,000. The client says I'm owed $3,000. So $3,000 of it is not in dispute. Even the client agrees that I'm owed the $3,000. So $3,000 is not in dispute. I've earned that money. I can't keep it in the trust account. So what do? I pay myself $3,000. Right? I also, $2,000 of it is also not in dispute the other way around. Because I only worked 16 hours. So my claim is for $8,000, but I have 10. So 2,000 of it is not in dispute the other way around. So what I have to do is I have to write my client a check for $2,000, write myself a check for $3,000, and now $5,000 is in dispute, and we go resolve that through the various mechanisms which we resolve that. And that is the correct answer. That is the correct answer, which I put on my essay, and my professor's like, no, you can't do that. It's in dispute. You can't spend the money. I'm like, not only can I have to. Because the money can't sit in the trust account because it's been earned. You can't keep the money in there because it's been earned. So you can't keep it there. So what you do is you write the client a check for $2,000, you write yourself a check for $3,000, and you go dispute the 5. And that is the correct answer ethically. And it took me 45 minutes to convince him I was right, which I totally am. So, yeah. So it took me, forever to convince him of that, but I was totally right. And I believe my professor was actually like on the advisory committee to like the state ethics board. And so he was really pissed because the student is like totally showing him up on something that was like, he is a subject matter expert on. And I was like, you're totally wrong. But I was right. So I won. I like this Silk Starlight says, there was this one American Lit AP who wanted to see original work in the essays you wrote for her. I argued she wouldn't be able to recognize something no one has done before. She didn't like me. Fair. Laura Lenny gave CA 279, said, hope you had a good day to Kurt. Flying Pussyfoot has been a member for 1 month. Alexitin gifted 10 gift memberships. Melissa Simuk has been a member for 6 months. Angie Torres gifted 10 gift memberships, and then I think gifted 10 memberships again. Nathaniel Shadows has been a member for 99 cents. Gordo Fabulous $5.99, and Bev D gifted 10 gift memberships. And Hen House Bath Company apparently also donated through PayPal, which I did. I get $10. I did really well on my ethics exam too. I beat it by 50 points or something absolutely ridiculous. I completely smashed the ethics part of the bar. I destroyed it. I needed 74 to pass, and I got something like 150 or something ridiculous. So apparently I'm extremely ethical. So yeah. So that's good. I remember this kind of fight I had with a female clerk who was going to be a clerk to John Roberts. I don't remember her name, but we kind of had a fight. And when I became a brand new lawyer in Virginia, Virginia required you to do this mandatory new lawyers thing, which substituted for CLE. And Texas kind of made you do the same thing too. They made you do this like new lawyers thing, which was a pain in the ass, but Virginia made you do it in person. And one of the people that was in my class was going to be a clerk for John Roberts, and she was such a snooty little brat. And we had an argument over something on ethics, and she didn't like me very much. No, not the one who leaked the abortion decision. This is way back. This is 2007 when I was a brand new lawyer. This is 2007 when I was a brand new lawyer. So this is this is way, way back. All right, well, I guess I'm going to sign off for now. That's the end of story time. I hope you enjoyed this Friday Night Frenzy substitute, I guess we'll call it. I hope you enjoyed whatever this was in all of its glory. And hopefully I didn't peak. Hopefully I didn't peak in law school. And I still got some room to grow. So, yeah. I've been on civil law. I'm going to try to get some sleep until later, my friends. I hope all is well. Cheers, my friends, and goodbye for now.